the respondents number 4 to 7, during the course of the day, failing which the interim order passed today would not inure to the benefit of the applicants. List the matter on 4-2.
4-2.
Okay.
Serial number 3, Marquez and Associates.
Public prosecutor. That's the first time. Same format, or the submissions of the learned counsels of the applicant. Learned AG, that's notice for 1 to 4. 1 to 4. This matter on 9-2.
9-2. Serial number 4, Ashok Kumar MN. Waiting for the applicant.
We will not proceed with the matter today. You file the legible copies of the annexures, more particularly the annexure 11, which is under challenge. Proxy counsel for the learned counsel for the applicant alone present. From the perusal of the memorandum of application, it is found that several copies, more particularly in page 137 of annexure 10 and annexure 11 are not at all legible. We are still not able to understand as to how come, in spite of repeated instructions, the scrutiny section is not taking required care and showing devotion in scrutinizing the file, though they are very few in numbers every day. Learned registrar to give suitable instruction to the concerned officials. Applicant is granted 3 days time to do needful in the matter. List the matter on 14-1.
14-1. Serial number 5, Satyanarayana P. Vagade.
Heard the submissions of the learned council for the learned AGA subsets notice for respondent number 1 to 4. So there is an interim prayer which states the impugned order by one is the AGA, but we are of the opinion that respondents are required to be heard before issuing or before granting the interim order. Therefore, this matter on 10-2.
10-2, serial number 6, NVN Swami.
How this application is maintainable with the present prayer?
Because the inquiry officer is of the same cadre. The complainant has complained against me. I'm a public prosecutor. And the inquiry.
Can you read the prayer, please?
It will refer facility or another appropriate fit of order. Watching the notice number so and so, 15/7/25, issued by the respondent number 3.
Yes. That notice is already expired. That notice has called for you to attend a particular day's inquiry
Yes.
by the inquiry officer.
Yes.
So
Subsequently,
that by lapse of time that has already become infectious. So where is the necessity of quashing it
in
arises?
99/25, subsequently they have been repeating, quoting the same notice. Annex F3.
That is true, Mr. Counsel. If that were to be the case, then by seeking quashing of one single day's inquiry notice, what purpose would be served?
Because
Framing of the prayer itself is incorrect.
following notices will also follow, my lord. The subsequent notices based on the first notice. If you see the annex A3, it is based on the first notice. It is not a fresh notice. It's a adjourning.
But the submission of learned counsel. Learned counsel for the applicant is physically present. After going through the memorandum of application, more particularly the relief sought for, including the interim prayer. Viewers, we thought of hearing about the maintainability of the application with the present prayer. Accordingly, we heard the submission, the learned counsel for the applicant on maintainability of the application. Orders on maintainability reserved.
Serial number 7, B. Krishna, AC Manjunatha.
With the delay of only 1 days.
Learned counsel for applicant is present. Learned AGA is physically present. Learned counsel for respondent number 3 is not present. AGA prays for time to file the reply statement as well as objections to IA1, if any. Time as prayed for is granted. List this matter on 9-2.
9-2. Serial number 8, NF Amrad.
Plastic. Office house. And counsel from both sides. Then the AGA files the reply with a copy having been served on the other side. Registry lists the matter of appropriate state on 12-2.
12-2. Serial number 9, M Madhusudan.
Yes. Representation of the applicant and learned counsel for the applicant has not rectified the delay, length of the delay in IA1 as an ultimate opportunity. This letter on 16-2.
16-2. Serial number 10, Bhajantri Associates.
Counsels from both sides are present. Then the AGA prays for time to file the reply statement. Time as prayed for is granted. List this matter on 12-2.
12-2. Serial number 11, KT Gardimani, PP Hegde Associate.
Please. Preparing for the respondents, my lords, for filing statement objections, your lords may kindly accommodate for some time for filing statement of objections. On behalf of the private respondents.
ನಿಮ್ಗೆ ಸಾಕಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಾಗಿದೆ ಅಂತ ಅಪೋಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಪ್ಲಿಕೆಂಟ್ ಕೌನ್ಸಿಲ್.
ಕೊನೆಯ ಒಂದು ಅವಕಾಶ ಕೊಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಪ್ರಾರ್ಥಿಸ್ತೇನೆ.
From both sides are present. Counsel for respondent 4-15, 17, 19 to 23, 26, under 27. Praise for the time to file the reply statement as an ultimate opportunity. Time is
10-2. Serial number 12, Mantesh Patil, Mohammed Shamil.
Lord, in serial
I'm
number
appearing for
12,
applicant, my lord.
I appear for R3, my lord. In this matter, IA, my lord, for impleadment of proposed respondents may be allowed, because if the prayer is allowed, then they will be directly affected. IA number 1 is for impleading proposed respondents. On the main matter, my lord, I've my draft objections are already shared. In a week's time, my lord, I'll file it.
Who appears for applicant?
I'm appearing for applicant, my lord.
Yes, what is your submission on the IA?
Lord, IA is for
No, applicant submission.
Swami, ಅವರು 456 serial number
Counsel for the applicant and learned counsel for respondent number 3 are appearing through video conferencing. Learned AGA for respondent number 1 and 2 is present. It appears that the learned counsel for the applicant has not come prepared in the matter. Hence, this matter on 17(2).
17(2), serial number 13, Raghavendra Ji Gayatri.
But on the previous date of hearing, we received the prayer for filing an interim application for substitute service. Tadanantara, we received a communication from the government advocate that the address of the respondent number 4 was received to her and she forwarded that to us. So we received the address and we have the IS also ready now. So kindly direct us. There are two options ready there. On consequent date of the hearing, we received a communication from the government advocate regarding his address.
How you are proceeding today in the matter?
But we are ready either way, sir. So kindly direct us. We are ready.
ನೀವು ನಮ್ಗೆ ಉಪಕಾರ ಮಾಡ್ತಿದ್ದೀರಾ ನಿಮ್ಮ ಕರ್ತವ್ಯ ನೀವು ಮಾಡ್ತಿದ್ದೀರಾ? ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ನೋಡಿದ್ರೆ ನೀವು ಏನೋ ನಮಗೆ ದಾನ ಕೊಡೋ ರೀತಿ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಐದರ್ ವೇ.
As we see here, we will go forward with the IS for substitute service.
ಅಷ್ಟು ಸಬ್ಮಿಷನ್ ಹೇಗೆ ಮಾಡ್ಬೇಕು ಒಬ್ರು ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆಗಿ ಅನ್ನೋದನ್ನ ಕಲೀರಿ. ಯು ಆರ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ ಟು ಎ ಕೋರ್ಟ್, ನಾಟ್ ಯುವರ್ ಫ್ರೆಂಡ್. Write the name of the newspapers in which
Javani ಮತ್ತು ವಿಜಯ ಕರ್ನಾಟಕ.
the counsel for the applicant and the learned Asia for respondent number 1 to 3 are physically present. The counsel for the applicant files an IA number so under provision so seeking permission for substituted service of notice upon respondent number 4 through newspaper publication. Peruse the IA. Third submission from both sides. In the affidavit accompanying the application, the applicant or deponent has stated that he could not serve the notice upon the unserved respondent number 4 through normal course. Hence, the respondent number 4 being a necessary party, he is required to be served through substituted service by way of publication in Prajavani and Vijay Karnataka newspaper having circulation in Shimoga district. Next one. The records show that in the ordinary course, the respondent number 4 could not be served. Hence, the IA under consideration is allowed and the applicant is permitted to carry out the newspaper publication or carry out the service of notice upon respondent number 4 through newspaper publication of the notice in the Kannada daily newspapers, Prajavani and Vijay Karnataka, having its circulation in Ayanur locality at the Shimoga district. The draft notice is required to be get approved by the registry by the applicant within 10 days from today, and the newspaper publication to be carried out rather than within 10 days, within a week from today, within a week from today, and the newspaper publication to be carried out on or before 29/1/2026, showing the date of hearing as of 3/3/2026. The newspaper publication to be carried out at the cost of the applicant. Yes.
3. Serial number 14, HM Umesh.
This case, the reply statement has been filed on 17/9. So with regard to the delay period, it also I need to file on the application delay.
References from both sides are available. Learned AGS submits that. We'll see. He has to file the reply statement of objections. The donation of delay. And time is granted as per
On the main, I have already filed.
till 16/2.
16-2. Serial number 15, Shivagondappa S. Julapi.
Yes, what is your submission?
Section of
ನೀವೇನ್ ಮಾಡಿದ್ರಿದೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? Learned counsel for the applicant and learned AGF respondents are present. It appears that the learned counsel for the applicant himself doesn't know the stage of the matter. Matter stands passed over. ನೋಡ್ಕೊಂಡು ಬಂದು ಹೇಳಿ. ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ.
Pass over.
Second round.
Serial number 16, Satyanarayana P. Wagade.
Learned counsels from both sides of the room. Learned ATA today files the reply statement with the copy having been served upon the other side. Registry to list this matter at appropriate stage around 18/2.
18-2. Serial number 17, Satyanarayana P. Wagade. Prakash Chowke.
I'm appearing for respond number 3, my lord. Reply already filed.
Learned counsels from both sides of the line. Learned counsel for respondent number 4 has filed Wakala as well as the statement of objections. Statement of objection. List this matter, registry to list this matter at appropriate stage. 12-2,
12-2,
interim order is extended till there.
serial number 18, Arvind H.
My lord, applicant, my lord, reply as to.
Appearing for respondent number 2, my lord. Reply already filed.
I'm filing reply.
Counsels on both sides. Learned AGA files the reply statement today. Copy having been served upon the other side. Copy to
I will collect it, my lord, register.
having been filed in the file in the office. Learned counsel for applicant to collect the same from the office. List this matter at appropriate stage on 17-2.
17-2, serial number
Yeah.
19, ML Suvarna.
I'm filing my.
Except the learned counsel, respondent number 2. Both sides, learned counsels for both sides are present. Learned AGA files the reply statement today. With copy having been served upon the other side. Registry statements. It is, since the respondent number 4 has not filed, has not been represented, has not filed reply. If the statement is taken that R4 has not filed reply statement. This is to list the matter of the press stays on date police. 18-2,
18-2,
interim order extended till
serial number 20, Shantraju, ADJ Associates, Vijay Ishwarappa.
learned AGA and learned advocate for the applicant are present. Learned counsel for respondent number 5 has not filed the reply. Learned AGA praised time to file the reply statement. The counsel of some things is in spite of giving the ultimate opportunity on 12/12/2025. However, considering that there is change in AGA, therefore, considering that the learned AGA has been posted recently, therefore, one more opportunity is granted, making it clear that no further opportunity would be granted to file the reply statement. Learned counsel for respondent number 4 is absent. List this matter on 10-2.
10-2, serial number 21, Raghunath S. Joyce.
My lord, appear for the applicant, my lord. My lord, amendment IA is ready, my lord. Today I have to file. Ready for filing.
Yes. There's no difference in the measurement of the data. There is some difference in the only other people. Like concept for the applicant is appearing through video conferencing and easier for responding is present. Like counsel for the applicant submits that since the length of the delay when mentioned in the 1145, no difference in delay. It is supposed to be. But no difference in delay unless there is limit of scrutiny ಯಾರಿದ್ದಾರೆ ಅವರಿಬ್ಬರಲ್ಲಿ ಬೀದರ್ಬೇಕು ಸಾಹೇಬರು ನಮ್ಮ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಕೊಂಡಿರಲಿಲ್ಲ submits that better. It is seen from the proceeding sheet that the registry has been repeatedly showing that delay mentioned in the IA is 1125 days. As such, there is no difference in delay. However, a perusal at IA 1 shows that the applicant has shown the delay as inverted comma about 3 years 1 month close inverted comma about another underline bracket and emphasis is applied at the birthwell close the bracket. Wrong mistake ಮಾಡಿದ್ರೆ ನಾ correction ಮಾಡಲ್ಲ. In the light of the same, though this tribunal has observed on 11/11/2025 that there is some difference between the length of the delay shown in the IA1 because of the calculation made by the registry, still the registry is continuing showing that there is no difference in delay. Incidentally, the learned registrar is also subscribing her signature throughout without even bothering to know the observation made by the tribunal. Hence, all the concerned to give their explanation in that regard.
I also praised by filing objections to the delay application. My mail I have filed.
ನೀವು ನಂತರ ಮತ್ತೆ ಬರುತ್ತ್ರಿ ಚಾನ್ಸು you get one more opportunity, right? List the matter asked. 21.
21. Serial number 22, Rangnath S. Jois.
appear per applicant. ಇದರಲ್ಲಿ ಡಿಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾ ವೆರಿಫೈಡ್ ಇನ್ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ದೇರ್ ಇಸ್ ನೋ ಡಿಲೇ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಏನಂದ್ರಿ we couldn't hear you properly.
ಅದೇ ಡಿಫರೆನ್ಸ್ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. pending a sectional.
Is the daughter of deceased government servant. The father of the petitioner died, my lord.
ಇಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಿದ್ದಾರಲ್ರಿ ಅವರು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಿದ್ದಾರೆ. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರೇನ್ರಿ ರೆಸ್ಪಾಂಡೆಂಟ್? ಯು ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಕ್ಯಾನ್ ವಿ ಟೇಕ್ ಇಟ್? ಯು ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್.
From both sides of the line. Learned AGA praise for time to file the reply statement as well as objections to IA1 if any. Time as prayed for is granted in 11-2.
11-2. Serial number 23, Nursing Raj and Associates.
Finally, the difference in
Somebody please proceed. Please go on. Please model for me. I don't know. In the door of the store, you need to know.
counsel from both sides are present. Learned AGA prays for time. Though the ultimate opportunity was given on 12/12/2025. However, considering the fact that learned AGA has been posted recently to this court hall, therefore, time is granted till 10/2/2026, making it clear that no further time would be granted.
10-2, serial number 24, Arjun Arcot, Shantapi Mallur.
Learned counsels from both sides are present. Learned AG prays for time. As an ultimate opportunity, time is granted till 9/2.
9-2, serial number 25, HM Nagendra.
Praise for the government. In this, in my request statement, I have shown you that 9 years delay, but the applicant states that it's 13 years delay. I have, in fact, the delay has been awarded to and replied that there is an unreasonable delay in my reply statement. The submissions in the reply statement will be adopted for Congress. I'll file a separate.
ಒಂದ್ ತಿಂಗಳು ಸಂಬಳ ಕೊಟ್ಟಿದ್ದೀವಿ, ಈ ತಿಂಗಳು ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಇರ್ತೀರಾ?
I'll file a
ಮಾಡಿ.
Learned counsels from both sides are present. Learned AGA since time to file statement of objections for IA1. Though, and however, he has already filed reply statement to on the main application. Time is as prayed for is granted till 10/2.
10-2, serial number 26, D. Krishna.
Learned counsels from both sides are present. Learned AGA prays for time to file the reply statement. Time as prayed for is granted as an ultimate opportunity till 12/2.
12-2, serial number 27, Bhagavat Associates.
But I appear for the counsel for the applicant. But here is a case, Lord, writ petition is allowed under A7 to insert the seniority of the applicant, which is corrected in the lower cadre. In the higher cadre, Lord, they have not corrected it. And actually, A7 is the order. Lord, we will find the correction at A9 405 in the cadre of Deputy Tahsildar. Prayer is, my Lord, too technical, my Lord. Government is standing too technically. Not higher cadre, they have to correct it based on the lower cadre. That they are not doing, my Lord.
Let them file
Due to which, Lord,
reply statements.
Learned counsels from both sides are present.
Learned AGF raised for time to file the reply statement. As an ultimate opportunity, time is granted till 5-2.
5-2. Serial number 28, Prakasham Patil.
Learned counsel from both sides are present. Learned AGF raised for time. Time as paid for is granted finally till 11-2.
11-2. Serial number 29, Basraj Patel GK. Respond number 3.
For the respond number 3.
Farida.
Learned counsels from both sides present. Learned counsel 3. Krishna Vyas files Wakala for respondent number 3 and face for the file reply statement. Registered to scrutiny the Wakala and is found in order to accept the same. List the matter on 11-2.
11-2. Serial number 30, HM Nagendra.
Vacation bed. You have the vacation bed and have survey. Now, day number 2 is complete and also second update also confirmed. Serial number, the page number 175 and 179 is not visible. The next 821 included also. And I like to use common application. Perfect.
Yeah, corrected application as well as IAs need to be served.
Good.
Common application. Only common application.
Learned counsels from both sides present. Certain observations regarding the lapses on the part of the scrutiny section in the registry was observed on 26/12/2025. It was also observed that in support of couple of IAs, when the affidavit sworn by the party to the litigation was required, the registry was not writing, accepting the affidavit sworn by the learned counsels for the parties. With the said observation, the matter had stood adjourned to today. Today, the registry has made a note in the proceeding sheet that with respect to IA number 2, with respect to IA number 1, the learned counsel has submitted that the said IA does not survive for consideration. The said submission is taken on record, since a similar submission is once again made by the learned counsel for the applicant. Consequently, IA number 1/25 stands disposed of as having become infectious. Next line, with respect to IA number 2, the registry has stated that what remedial action you have taken for IA number 2?
Common application.
What remedial action you have taken with respect to observation made by us?
ಅದಕ್ಕೆ ಪಾರ್ಟಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀನಿ ನಂದು ಮೊದಲು
ಹಾಕಿದ್ದೀರಿ.
ಹಾಕಿದ್ದೀನಿ ಫಸ್ಟ್ ಅಪ್ಲಿಕೆಂಟ್ ಫೈಲ್ ಆಗ್ತದೆ. applicants are retired. Common employee, common employee. No common employee.
With respect to IA number 2, the registry has mentioned that the applicant needs to replace the affidavits filed in support of the said application. The learned counsel for the applicant submits that he has replaced the affidavit to IA number 2. Next line, needless to say that this tribunal had not directed either of them to replace the affidavit on their own. Once a matter is posted before the court of the tribunal, not just the parties, even the registry is also required to follow the directions given by the court of the tribunal, or if it requires any such direction, it is required to solicit the same from the tribunal. In the instant case, once again, on its own, the registry has taken the decision and proceeded in accepting the affidavit without taking a nod from the tribunal in that regard. Thirdly, nowhere in the observation dated 26/12/2025, it was observed by this tribunal that all the supporting affidavits to the IAS have to be necessarily sworn to by the parties to the litigations alone. However, it appears that the learned registrar has misconstrued our observation dated 26/12/2025 and has circulated an instruction, bracket, probably orally, close the bracket, among the staff, stating that asking them to accept only the affidavit filed by the applicants and respondents, as the case may be, in support of their IAs, and not to accept the affidavits filed by the advocates or the third parties, comma, by stating that the same was the observation made by this court of the tribunal on 26/12/2025. We expect a learned registrar to show more indulgence in going through the directions or the observations made by this registrar. List the matter on 12/2.
12/2. For orders,
Bishop. Then the adjustment order. Government interest in matter by local anytime we should article for organizing inquiry. That's the time.
ಆಗಲಿ ಸ್ವಲ್ಪ ರಿಪೇರಿಗಳಾಗ್ಲಿ ಮಾಡುವ. Yes.
for order serial number 31 Krishna S. Vyas.
Date is too long.
ಇಲ್ಲ ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿರೋದೇ ಶಾರ್ಟ್. ಈಗ ನೋಡ್ತವ್ರೆ ಮಾರ್ಚ್ ವರೆಗೆ ಡೇಟ್ಗಳು ಇಲ್ಲ.
ನನಗೆ ಕಷ್ಟ ಇದೆ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಟಿಕಲ್ ಸೆಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಅಪ್ಲಿಕೇಶನ್
Yes, we have considered everything, yes.
I am for respond number 3, man. I have filed my statement to reply.
Postal receipt origin is put. Okay, good. Copies ಕೊಟ್ಟ ನೋಡಿ ಇಡಬೇಕು. Learned counsels from both sides person. The counsel for respondent number 4 has filed a memo seeking permission for him to retake from appearing for respondent number 4 in this matter. Along with the memo of retirement, the learned counsel has also filed a photocopy of a retirement notice said to have been sent by him to respondent number 4, along with speed post receipt and a postal track printout, and submits that the notice has been duly served upon the respondent number 4. Respondent number 4 was called out. Oops.
Respondent number 4 Manjunatha LK.
He has remained absent. Not fair. Considering the reasons shown in the memo under consideration, and of the fact that a retirement notice has been duly sent to respondent number 4, comma, the learned counsel, Shri Basuraj Patel JK, appearing for respondent number 4, is permitted to retire from appearing for said respondent number 4 in this application. Next slide. Since the respondent number 4 has remained today, even after service of retirement notice by his counsel appointment, in the best interest of justice, a court notice is ordered to be issued to him. Accordingly, issue emergent court notice upon respondent number 4, returnable by 29/1.
29/1.
In the meantime, in the meantime, 29, yes.
Serial number 32 BM Santosh, Sarita Nair.
Both sides present. Statement to ಫೈಲ್ ಮಾಡ್ತಿದ್ದೀರಿ ಕೊಡಿ. ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ತಗೊಂಡಿದ್ದೇವಾ? The counsel for respondents number 5, 6, 7, 9 and 10 files. Their replace statement. Duly certain copy thereof to the other side. Next line. Perusal of the other sheet would go to show that even though issuance of fresh notice was ordered upon respondent 11 as long back as on 1/12/2025. However, the applicant has taken steps only on yesterday, that is on 7/1/2026. Registry to proceed to issue notice to respondent number 11. Call on 4/3.
4/3. Serial for Anderson IS serial number 33. Satishan Patalagi, DN Sadhya Reddy.
The counsels from both sides present. Hence to file the statement of objection if any to IA1 and IA2 filed by the applicant. List the matter on 3/2.
With your lordships, permission.
Yes.
Have you permitted to permission? In fact, after vacating of the mutual model, subsequently an order has been passed to recover the amount. Even though represent respondent number 3 remains unrepresented. You are asked to order.
ಸಂತೋಷ ಏನಾಗ್ಬೇಕು ಇದಕ್ಕೆ?
Earlier there was a mutual model.
Exactly.
Subsequently, on 11 back, when your lordships order one,
Huh.
supposed to take steps. On
Ah.
1410, I have a question. On 1410 itself, we took steps. Since we was not keeping it with serious radical surgery, was not able to keep myself.
With certain observations, the interim order was not extended. After noticing certain lapses on your part, when the court has not extended the interim order with some reasons, automatically it cannot be extended. Now we have filed an IA. They have got a right to submit their objection if any to the said IA. That's it.
At least if I will make it for. I'm on 18 by 2025.
You can file memo on the registry, no problem. Yeah. Push the matter on. Put it.
Starting pay to.
Yes, next.
3-2, serial number 34, M. Madhusudan.
Lord, appearing. Lord,
Time out.
Both side present. IA 2, correction of length of the delay. Formality. All over to rectify the same. Within 3 days from today.
please, Lord.
The respondents, if not already filed a statement of objection to IA1, to file the same.
And for the main one, reply for the one. They're not filed on main. Three seven 25. I have sought time here also to file reply statement and objections to present. And they are
And
filed
also-
also for on.
Replace statement. As finally time is granted, is the matter on. 16-2.
16-2, serial number 35, K. Srinivasa.
The responses from both sides present. IA 2 for amendment of length of delay, format hacking, allow the applicant to carry out the amendment permitted in 3 days. The respondents to file their statements of objection if any to the said IA1 within 2 weeks from today. Finally, the time as prayed is granted. List the matter on 10-2.
10-2, serial number 36, Midland Company, DN Sadhav Reddy.
Amendment of the correctness of number.
But in this case, you also it appears that my office has already filed the reply statement on 3/12/25. However, the order sheet on 3/12/25, nothing is being shown in the downloaded copy.
On 3/12/25, the registry has shown that you have not filed replace statement. File Lydia not replace statement. ಯಾವತ್ತಿದೆ ಸಿ ಲೆಟರಲ್ಲಿ? R3 ಹಾಕಿದ್ದೀರಿ replace statement? Already filed. ಈಗ ತಗೊಂಡು 3 days ಆದ serial 35.
The objection is taken on record.
ಅಯ್ಯೋ ಅಲೋ ಮಾಡಿ. Statement of objection to IA if any ಹಾಕಿ.
Please, on the mail I have already filed.
ಮಾಡಿದ್ದೀರಿ ಬಂದಿದೆ 10-2.
10-2,
IA allowed carry out the amendment. Please.
serial number 37, Satyanarayana P. Vagade.
The million I have filed a lawsuit. On the 240 days delay, I required to file.
Period 36 ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಮಾಡಿ IFR amendment allowed to file statement of objection within 3 weeks from today. 17-2.
17-2. Serial number 38, Srinivasa MA.
Same order. ILO. Statement of objection 17-2.
17-2. For further arguments, serial number 39, M. Narayan Bhatt, LK Srinivas Murthy, RB Prakash. Ready. Pass over. Serial number 40, Maitreyi Krishnan. Pass over. Serial number 41, Bharati and Associates. Pass over. Serial number 42, Archana Murthy. Pass over. For hearing, serial number 43, Midland Company. Pass over. Serial number 44, Bhagavat Associates.
Learned counsel for the applicant is present. Both learned counsels from both sides are present. At the request of learned counsel for the applicant. Time is granted. Any selection. Is this matter is connected with the other similar matters? Election MEA? Not connected.
16-2. Serial number 45, DM Santosh, Mama Shamil.
Pass over.
Pass over.
Lord, in this matter, may I make one submission, Lord? Lord,
Yes.
in this matter, Lord, similar matter where the very same recruitment process was challenged, the application was allowed by this court, and that has been challenged by the KPSC before the High Court. The High Court has stayed the order of this tribunal, and the same subject matter is now pending before the High Court, Lord. I may be permitted a week's time, Lord. I have applied for certified copies. I will furnish the same before your Lordship.
Learned counsel from both sides present. Learned counsel for respondent number 2 stating that in a similar matter, the Honorable High Court has passed an interim order of stay. He submits that he submits that according to information received by him. In a similar matter, so the Honorable High Court of Karnataka has granted an order of stay. He prays 10 days time to correct the details, including the certified copy of the order passed if any, and to make his submission. The time as prayed is granted. Just the matter on 29.
I like what the.
Yes, please.
Intentions in that case are different and in this case are.
ಆಗ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ತಗೊಂಡ್ಕೊಳ್ಳಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅವು ಜಾಸ್ತಿ ಬೈಯೋಣಂತೆ
29-1, serial number 46, Balaji Associate.
I'm for the applicants, my lords. This case pertains to the economically weaker section reservation, my lords. The government order which we are seeking benefit of government order is stayed by the Honorable Supreme Court, my lords. Economically weaker section reservation, 10% reservation, my lords. Now the Supreme Court has stayed the matter and directed the government to follow old reservation policy, my lords. Policy was brought by the state government pursuant to the judgment passed by the Honorable Supreme Court in 5-judge bench decision, my lords. Matter is of 2024, my lords.
So what is your submission? You appear for whom?
We are for the applicants, my lords.
Yes,
Seeking
what is your submission?
It may be adjourned by 4 weeks, my lords. The government order is stayed by the Supreme Court now.
Produce the order copy, please.
Please, my lords. Please, my lords.
We'll pass over the matter, produce it.
My lords, kindly have it tomorrow, my lords.
Absolutely not. ನಿಮ್ಮನ್ನು ಕೋರ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ಕರೆಸ್ಕೊಂಡಿದ್ದೇವೆ ನಾವು. You had remained absent successively. Yes.
Restriction is enclosed with the reflection is in the reflection. We are filed in the 25/2024.
ನೀವೇನ್ ಹೇಳ್ತಿದ್ದೀರಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತಿದ್ದೀರಿ ರಿಪ್ಲೇಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತಿದ್ದೀರಿ ಯು ಆರ್ ಫಾರ್ R5. ಹಾ
Application number 4/2023 is enclosed with the reply statement. The EWS 10% reservation.
ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಹೇಳ್ತಿರ ಸಬ್ಮಿಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಏನಾರು ತಾವು ಹಾಕಿದ್ದೀರಾ?
Yes, sir. It is along with the replacement.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಇದೆಯಾ?
Yes, sir. Writ petition, civil, number 4/2023.
Next page.
Number 7. Page number 7.
ಯಾವಾಗ ಆಗಿದೆ ಆರ್ಡರ್ ಇದು? ಎಲ್ಲಿವರೆಗೆ ಆಗಿದೆ ಆರ್ಡರ್ ಇದು? ನೀವು ಫಸ್ಟ್ ಬಾಯಲ್ಲಿ ಹೇಳಿ ಆಮೇಲೆ ಕುಡಿ. ಈ ಕೊಟ್ಟಿರೋ ಆರ್ಡರ್ ಅಲ್ಲೇ ನಿಮ್ಗೆ ಏನು ಅಂತ ಹೇಳಿಕ್ಕೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
25/4/2023 ಅಲ್ಲಿ ಆಗಿದೆ.
23 ಎಲ್ಲ ಇದೆ. ಎಲ್ಲಿವರೆಗಿದೆ ಇದು ಆರ್ಡರ್? ಓದಿ ನೋಡ್ರಿ ದಯಮಾಡಿ.
The improved order dated 27/23 will not be implemented till the next date of hearing.
Till the next date of hearing. 23 ಏಪ್ರಿಲ್ ನಂತರ ಯಾವಾಗ ಬಂದಿದೆ, ಎಲ್ಲಿವರೆಗೆ ಬಂದಿದೆ, ಎಷ್ಟು ಸರ್ತಿ ಬಂದಿದೆ ಮ್ಯಾಟ್ರು?
My lords, may I make a submission?
ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಅವ್ರು ಹೇಳಿ.
ಇಲ್ಲೇ ಕಾಪಿ ತಗೊಂಡಿದ್ವಿ.
ನೀವು ಫಸ್ಟ್ ಬಾಯಲ್ಲಿ ಹೇಳಿ ಆಮೇಲೆ ಕೊಡಿ. ಮ್ಯಾಟರ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಪಾಸ್ಡ್ ಓವರ್.
Pass over.
Please, my lord.
Serial number 47, Ravindra Ji Gayatri, Basraj Sapanavar.
I am appearing for.
Kindly pass.
our serial number 48 Srinivasa MA. Pass over. Serial number 49 Sidhar Negde.
In this, the applicant has filed an amended petition subsequent to me filing my statements, reply statement. And I do need to file an additional reply statement, given that he has amended certain, produce additional documents also. In counsels from both sides are present, and the request of both the counsels. This matter on 22. For filing for.
Haki.
As stated,
Serial number 50 Chandrakanta D Janavade.
Pass over.
Pass over. Serial number 51 Subbaravan Company. Pass over. Serial number 52 Bhagavat Associates.
Yes. Learned counsel from both sides are present. Learned counsel for the applicant, praise for time. Time as prayed for is granted, making it clear that no further adjournment would be granted. This matter on 16/2. Interim order extended till the
16-2 serial number 53 Diva Anil Kumar.
learned counsels from both sides are present. Learned counsel for the applicant praise for time. Time as prayed for is granted till 11/2.
11-2 serial number 54 Prem Kumar P. I'm applicant.
Same order. Date 17/2.
17-2 serial number 55 DT Kumar.
But in this, I've changed the title of 15 of the resource, right? They say the title of the irrigation.
Pass over. Pass over. Serial number 56 Chandrakant 4 KT Ready Money.
Request for 6 and 7.
It is taken as not filed long back. I had. Counsels from both sides are present and pray for time. Time is granted as prayed for till.
Govind Raj K.
Pass over.
Pass over.
In the packet same article 17/2.
17-2 serial number 58 M Madhusudan.
Of 6 and 7, please.
Respondent number 6. DL Tippeswamy. Respondent number 7. Santosh Kumar R.
No counsel for the applicant. The AGA for respondent number 1 to 5 and 8 are present. Respondent number 6 and 7, who earlier appeared as partying persons, are called out. They have remained absent. The counsel for the applicant. Place for time, list the matter on 17.
17 to serial number 59. Shastri and Shastri Associates.
ಮುಂದಿನ ತಿಂಗಳು ಬನ್ನಿ. Both side present. The matter on 60. 60 and
57 and 70.
ಬಂದ ಕೇಳಿ ಸೇಮ್ ಡೇಟ್ ಕೊಡು.
Serial number 60. Virupaksha Associates.
Appearing for applicant, my lord. I praise for time, my lord, for short accommodation.
Recalling the order. Please go. Is also reflected. ಕಾಸ್ಟ್ ಎಷ್ಟು ಹಾಕೋಣ? ಕಾಸ್ಟ್ ಎಷ್ಟು ಹಾಕೋಣ? ಹೇಳಿ. ನೀವು ನಮಗೆ ಬಿಟ್ರೆ ಜಾಸ್ತಿ ಆಗ್ತದೆ ಆಮೇಲೆ. Number 2, 5 size so and section so seeking to recall the order dated 3/12/2025 and to permit it to file refresh statement. Counsel for the applicant submits no objection to allow the said idea and terms. Here is the affidavit accompanying the application. Heard both sides. Here is the application. Here is the affidavit accompanying the application. In spite of granting sufficient opportunities, the respondent number 2, in spite of granting several sufficient opportunities, even as ultimate opportunity, the respondent number 2 had not filed a replay statement. As such, under the order dated 3/12/2025, this tribunal had taken that respondent number 2 has not filed a replay statement. Consideration is filed. However, affidavit accompanying the application shows no convincing reason for non-filing of the replay statement on the previous on the earlier occasion when sufficient time was granted to them. Still, considering the no objection statement made by the learned counsel for the applicant and the circumstance of the case, we are of the view that imposing cost upon the respondent number 2, the I under consideration be allowed accordingly. I number 2 stands allowed on a cost of rupees 500 payable by respondent number 2 to the state in the registry of this office within a week from today and filing a complaints memo along with original receipt to that effect within the said time in the register. Subject to the payment of the cost, the reply statement filed by the respondent number 2 today is taken on record. It is also made clear that non-payment of the cost as ordered above and within time would deny the benefit of the order passed on IA number 2 upon the respondent number 2. Registry to reach the matter at the appropriate stage on 17th.
17-2. Serial number 61, Super Company. May pass the time.
The counsels from both sides are present with the request of learned counsel for the applicant. Listening matter on 17-2.
17-2. Serial number 62, Basraj Patel, GK.
Let's start in the application. Consider whether the respondent can refix the intention. Never possible.
Is good.
Terms of credit tag. Last title credit tag and credit tag.
No objection. Right. The present application was filed by the applicant herein under section so Act. Seeking quashing of the order dated 12/3/2025 issued by the respondent number 3 wide annexure A7 and A9 and also for a direction to respondent number 2 and 4 to consider his representations and refix the salary and the pension and to extend all consequential benefits. The respondents are being represented by the learned AGA. Learned counsels from both sides are present today. Next, learned counsel for the applicant files a memo today stating that considering his representation, his salary has been refixed and a necessary order has been passed. As such, the main application does not survive for consideration. The learned counsel for the applicant, while making submission on the lines of the memo, also submits that the difference amount also has been credited to the account of the applicant and prays to dispose of the matter accordingly. Learned AGA submits his no objection to record the memo and to dispose of the application accordingly. Next line, in the light of the above, the application stands disposed of as having become infectious.
Serial number 63, Basraj Patel, GK.
Credit tag.
ಆರ್ಡರ್ ಆಗಿದೆ, ಕ್ರೆಡಿಟ್ ಆಗಿದೆ.
ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಈಗ ನೀವೇನ್ ಹಾಕ್ತಾ ಇದ್ದೀರಿ, ಬರೀ ಆರ್ಡರ್ ಆಗಿದೆ ಅನ್ನೋದಷ್ಟೇ ಹಾಕ್ತಾ ಇದ್ದೀರಾ ಅಥವಾ ಕ್ರೆಡಿಟ್
ಇಲ್ಲ ಕ್ರೆಡಿಟ್ ಆಗಿಲ್ಲ, ಆರ್ಡರ್ ಆಗಿರೋದು ಮಾತ್ರ
ಹಾಕ್ತಾ ಇದ್ದೀರಿ? ಕ್ರೆಡಿಟ್ ಆದ್ರ ಮೇಲೆ ಈಗ ಹಾಕಿರಲ್ಲ ಮೆಮೋ, ಅಂತದೇ ತಗೊಂಡ್ ಬಂದು ಹಾಕಿ ಕೊಡಿ ವಾಪಸ್ಸು. Counsels from both sides present and counsel for the applicant stating that the respondents have passed a necessary order meeting his prayer in the application. However, he is awaiting the credit of the amount is account. With this, he prays for 10 days time. List the matter on 28. 1. ಅವತ್ತಿನ ದಿವಸ ನೋಡ್ಕೊಂಡು ರೆಡಿ ಮಾಡಿ ಬನ್ನಿ.
28-1, serial number 64, J. Prashant.
I'm for the applicant, my lord. Ready, my lord. Kindly pass over.
Pass over. Serial number 65, Siddhi Law Advocates. Pass over. Serial number 66, PM Nanjareddy.
Learned counsel from both sides are present, and the request of learned counsel for the applicant, place this matter on 17-2.
17-2, serial number 67, Shastri and Shastri Associates.
16th February. Both sides present, list the matter on 16-2.
16-2, serial number 68, Midland Company.
Pass over.
Pass over.
69.
Serial number 69.
Pass over.
Pass over. Serial number 70, Shastri and Shastri Associates.
Both sides present, list this matter on 16-2.
16-2. Serial number 71, M. Venugopal.
Pass over.
217, advocate same. Without approaching the competent authority, they directly.
Order sheet. 71.
Very close,
Same ಇದೆ. ಸ್ವಲ್ಪ ಕೊಟ್ಟಿದ್ದೆ. ನೀವು flow ಹೋಗಬೇಕು. None appeared for the applicant either physically or through video conference. Lord AGF for respondents are also. A perusal of the order sheet would go to show that in this application, several and sufficient opportunities, even as finally and as a last chance, were all given to the applicant to address his arguments. In spite of the same, today, neither the learned counsel for the applicant is present nor has made any submission for his non-appearance. Hence, it can be inferred that the applicant is not interested in prosecuting the matter. As such, the application stands dismissed for non-prosecution. It's no order as to cost. 71 in the 71 75.
Serial number 76, MC Baswaraju.
The reply has been filed on 16/12/20. Well, my apologies for this. I'm filing the reply statement.
ವಾಪಸ್ ಕೊಡಿ.
Office out. My apologies. I filed necessary application.
ಅಲ್ವೇ ಮತ್ತೆ ಗಡಿಬಿಡಿ. Yes, what is your submission?
Password.
What for?
Housing.
What is the stage of the matter? ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ಲಿ? Per hour or per day? ಈಗಾದ್ರೆ ನಿಮ್ ಸೀನಿಯರ್ಗಳು ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು? ಇದೇ ವ್ಯತ್ಯಾಸ ಈಗಿನ ಹೊಸಬರಿಗೂ ಹಳೆ ಜನರೇಷನ್. ಕೈಲಿ ಮೊಬೈಲು, UPI ಪೇಮೆಂಟ್ಗಳು ಎಲ್ಲ 3 ಡಿಜಿಟ್ ಮೇಲೆ ದುಡ್ಡು ಎಷ್ಟು ಅಷ್ಟೇ ಹೊರತು ದುಡ್ಡು ಯಾಕೆ ಪ್ರಶ್ನೆ ಬರೋಲ್ಲ. ಯಾವ ಸ್ಟೇಜ್ಗಿದೆ ಕೇಸು, ಏನು ನಿಮ್ಮ ಮೇಲೆ ಅಬ್ಲಿಗೇಷನ್ ಇತ್ತು, ಡೈರೆಕ್ಷನ್ ಏನಿತ್ತು, ಅದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿದಿರ? ಏನಿಲ್ಲ. ಕೇಳಿದ್ರೆ ಸೀನಿಯರ್ ಬರ್ತಾರೆ. ಸೀನಿಯರ್ ಆಫೀಸಿಗೆ ಸೇರಿದ್ಕೊಳ್ಳಿ, ನಿಮ್ಗೊಂದು ಚೇಂಬರ್ ಬೇಕು, ಫೋನ್ ಬೇಕು, ಓಡಾಡ್ಲಿಕ್ಕೆ ವೆಹಿಕಲ್ ಕೊಡಬೇಕು, ಬೇಗ ಮನೆಗೆ ಬಿಡಬೇಕು, ಸಂಡೇ ಬಾ ಅನ್ಬಾರ್ದು, ಫೈಲ್ ಓದ್ರಿ ಅಂತ ಕೇಳಲೇಬಾರ್ದು, ಫಾರ್ಮ್ಯಾಟ್ಗಳು ಬೇಕು ಅಲ್ಲವೇ? ಮತ್ತೆ ನಿಮ್ಗೊಂದು ಅಬ್ಲಿಗೇಷನ್ ಇದೆ, ಡೈರೆಕ್ಷನ್ ಇದೆ, ನೋಡ್ಕೊಂಡು ಬಂದು ಏನಂತ ಹೇಳಿ. It appears that the learned counsel for the applicant is not aware of the stage of the matter. The matter stands passed over.
Pass over. Serial number 77. Rangnath S. Joyce, AM, Gunaranjan.
Appear for the applicant, my lord. In this case, so far as KPS is concerned, they have filed the reply, my lord. State government said it has nothing to do. So matter has to be heard, and so far as the reply filed the KPSC, my lord, I have filed a rejoinder documents. Today I am filing a short date. Next week it may be had, on that day I will argue, my lord.
Both sides present at the request of learned counsel from the applicant. Time is granted till 18/2.
18/2.
Earlier, my lord, January if possible, my lord.
Serial number 78.
Dates ಇಲ್ಲ.
Serial number 78. Bhajanti Associates.
Both sides are present. The request of learned proxy counsel for the applicant. Time is granted till 18/2.
18/2. Serial number 79. PV Manjunatha.
Same argument, proxy counsel on our line, counsel.
18/2. Serial number 80. KM Prakash. DN Saudharity.
Same.
18/2. Serial number 81. Mohammed Ashar CK.
Sir, hearing for the applicant in the matter. The last date of hearing and the objections were filed, but I have not received a copy. The Junior Council appeared in this honorable court.
ನೀವು ಮನೆ ತಂದು ಕೊಡ್ಬೇಕಾ ಹೇಳಿ, ಅಡ್ರೆಸ್ ಕೊಡಿ, ಲೊಕೇಶನ್ ಕಳಿಸಿ, ಸಾಯಂಕಾಲ ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೇನೆ.
ಮಂಡೇ ಗಂಟೆ ಒಂದು ಟೈಮ್ ಕೊಟ್ಟು ನಾನು ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ, ಮತ್ತೆ ಕಾಪೀಸ್ ನಾಟ್ ಸರ್ವ್ಡ್ ಅಪಾನ್ ಮೀ ಅಂದ್ರೆ ನೀವು ಇಲ್ಲದೆ ಹೋದ್ರೆ ಇಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಇದ್ರೆ ತಗೊಳ್ಬೇಕು, ಅವ್ರು ಕೊಡದೆ ಹೋದ್ರೆ ಕೇಳಬೇಕು. ಈಗ ನಾನು ಕೇಳಿದ್ ನೀವು ಬೇರೆದೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ದಿ ಮ್ಯಾನರ್ ಆಫ್ ದಿ ಸಬ್ಮಿಷನ್ ಅಂಡ್ ವಾಟ್ ಸಬ್ಮಿಷನ್ ಅವರ್ ಮೇಕಿಂಗ್ ಅದನ್ನ ಹೇಳ್ತಿದ್ದೇನೆ ನಾನು. ನೀವು ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ.
I am serving another copy.
18/2. Serial number 82. Najreen La Chambers. Savita PH. 18/2. Serial number 83.
83, 84 concept.
Pass over.
Previous hearing pass over India. X to Z. Food safety.
Serial number 15. Pass over matter serial number 15. Shivagondappa S. Julapi.
ಏನ್ ಸ್ಟೇಜ್ ಅಂತ ನೋಡ್ಕೊಂಡು ಬಂದ್ರಿ ಅಲ್ವೇ? Called again, content for the applicant. Praise for time. As finally, time as period is granted to do it. It is a matter of 9-2.
9-2.
Second resolution.
Additional list two for further arguments, serial number 1 and connected matters, Bhagwata Associates, KV Dhananjay, PS Rajgopal Associates.
If the private respondent must be ready, I request for 3 o'clock please. Great.
Pass over.
Main list.
For further arguments, serial number 39, M. Narayan Bhatt, LK Srinivas Murthy, RB Prakash.
ಅವ್ರು ಹಾಕಿದ್ರೆ ನೀವು ಹಾಕ್ತಾ ಇದ್ದೀರಿ.
Direction for me actually. So I
But
thought that
you are respondent too.
Not respondent.
ಕೊಡಿ ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರದ್ದು ಇಸ್ಕೊಳ್ಳಿ
Like-
ಇವ್ರದ್ದು ಇಸ್ಕೊಳ್ಳಿ.
Same letter I am also.
Yes.
Mail. The only question Sanjana can raise is 3A may not he is entitled to be selected. There was no requisition for preparing at the time of preparing additional list for filling up of 3A at all. 3A category was never been called for by the appointing authority to be filled up. So I was there, so there's no question of by sending the 3A list at all, 3A category vacancy at all. My underlying contention is instead of rural, I should have 3A should have been considered first. Yes, concerns many sometimes in both the at least in the recently of Kerala, Musa, we show Musa, the elevator. You see, that from there, they are argued against Mr.
R4 replace statement. R4 replace statement. R2 replace statement ಎಲ್ಲಿದೆ? R2 you have filed replace statement, right? 31/1/2020. They have filed it. They have filed. ಮತ್ತೆ ಇದನ್ನ ಯಾಕೆ ಕೊಡಲ್ಲ? ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಇದ್ರ ರಿಪ್ಲೇಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಗಳನ್ನು ಯಾಕೆ ಕೊಡಲ್ಲ? One second. According to applicant, the respondent number 3 was not selected under rural quota.
Please.
Therefore, you are directed to produce the list. ಇವತ್ತೇನ್ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಕೊಡಿ. You received the copy of the memo?
Yes, ma'am.
You are for the applicant.
Yes, ma'am.
What is your submission on the document produced along with the memo?
Document, my lord. For which post, which candidate was selected under the GM rural category and he did not report for duty not forthcoming. Category stated in this memo. It includes other categories also. I cannot differentiate under which category that candidate was not selected. Whether under 2A or under ST or under rural. He is not forthcoming from that. The KPSC has to make a categorical statement in that regard. The first submission. Second submission is Mr. Kulkarni's case. That aspect, my lord, Mr. Anil Kulkarni's name surfaced in both the list, residual credit trader as well as in the Hyderabad Karnataka list. He opted for Hyderabad Karnataka list. He was selected in the GM category, and I am the next meritorious candidate and is in the GM category in residual parent cadre.
The direction given to you on 11/12/2025 reads as below. After hearing the submissions from both sides, we are of the view that respondent number 2 be directed to produce form number 7 and related documents to show that the selection of respondent number 3 was strictly under rural category coming under GM rural 3A category. Whether the document produced by you gives any input in that regard.
The lordship of kindly say number 1 itself is rural candidate. Number 2 is also rural candidate. Number
One
4 is
second.
also rural candidate. There is no, he belongs to 3A, not only 3A, general merit 3A. There is no even in the 22 people which have been sent for filling up of his additional day. 3A does not arise at all. So my line of friend cannot claim 3A as a 3A candidate, cannot claim any putting it, his name in the additional list at all. There is no vacancy as far as 3A is concerned. All the 3A candidates are reported for duty probably. And this the letter of the first respondent asking me to fill up the first letter is.
Hello, 1 minute.
Please.
1 minute. It is noted in the order sheet dated 11/12/2025. What I have read just now,
Please.
above that, the previous paragraph,
Please.
I read it from the beginning. 11/12/2025. Learned counsels from both sides present heard the arguments of the learned counsel for respondent number 3 in part. At this juncture, by the rival submissions from both sides, it is reflected that though the respondent number 2 has stated that respondent number 3 has been appointed under rural category as GM 3A rural candidate, it is seriously objected by learned counsel for the applicant, stating that there is no documentary proof to show that respondent number 3 has been selected under the rural category. After hearing the submissions from both sides, we are of the view that respondent number 2 be directed to produce form number 7 and related documents to show that the selection of respondent number 3 was strictly under rural category coming under GM rural 3A category. This is the recording made on that day.
Yes.
So you are directed to produce document to show that respondent number 3 Vishwanatha Tippanna Hosahudaya was selected strictly under rural category coming under GM rural 3A. Where is the document?
No, there is that is under the vacancies will be either under the rural or it is a unfilled vacancies of the categories. Several categories which the first respondent will provide it to us. But the category whoever was fits into the rural or for the 3A or for 2A or GM, not accordingly, because only 10% of the person or 10% of the vacancies is being earmarked in the additional select list. But we will select it from the additional list. Who are categories which has been going to fill up and basing on the merit.
On basing on the merit, my lord, we have filled up rural category. Okay, vacancies were available, so we have filled up rural category. Respondent number 4. We
Yeah. See, the whole issue is under which category respondent number 3 is selected. Under GM 3A or 3A rural.
See the rural. That is the para 8 of my, right from the day 1, the para 8 of my replace.
So to that extent, you were directed to produce a copy apart from Form 7. Apart from Form 7, it was you were directed to produce.
That question arises when under front is 3 RL candidate or is entitled for candidate.
If there is no vacancy at all, and there is no forwarding of that particular vacancy to me, then the question does not arise at all.
That forwarding comes only when we are sure that the third respondent is selected under rural. The question here is whether he is selected under 3A vertical reservation or 3A rural horizontal reservation.
Because the vacancy is only for the rural only.
Notification.
Not for 3A also.
Notification.
No, the vacancy is only for 3A.
Vacancy
is for rural only.
At the beginning of the recruitment or after the select list is?
After the select list. First list after select list.
We are asking you at the first stage itself.
First stage,
First, he is claiming that respondent number 3 is selected under 3A rural.
No, 3A only.
My submission is he was not selected under rural categories. He was selected as a GM candidate.
As per the order sheet,
again it's confusing.
No, my lord.
No. Order sheet dalli clear ಇದೆ.
GM 3A. He selected under GM 3A category is claiming. Only 3A is
here last time 3A rural ಅಂತಿದೆ.
3A rural ನಲ್ಲಿ his claim is 3A rural ನಲ್ಲಿ claim ಇಲ್ಲ. 3A rural ನಲ್ಲಿ ಯಾರು ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ, that has to auto come to me 3A again. Because I am senior but very more meritorious candidate. That is the contention.
If he is not a rural candidate, then he falls under GM 3A category. And
I'll read out the once again for your information. It is reflected that though the respondent number 2 has stated that respondent number 3 has been appointed under rural category as GM 3A rural.
Contended by him. Contended?
No. I'm reading the observation of this court on last occasion in the order sheet. I'm not talking just like that. I will repeat it once again. It is reflected that though the respondent number 2 has stated that you have stated, respondent number 2 has stated that I'll read the name Vishwanath. He has been appointed under rural category as GM 3A rural.
Please.
Rural.
It is seriously objected by learned counsel for applicant, stating that there is no documentary proof to show that respondent number 3 has been selected under rural category. Now your contention is he is selected under 3A rural category. He is saying that
he is not under
Vishwanath is not selected under 3A rural.
Yes.
He is selected under only 3A.
Yes.
So to that extent, you were supposed to submit the documentary proof.
Two aspects I wanted to make.
Now, the second aspect I am not asking you. I am not asking you about Form 7.
No, what I mean to say is, Form 7, there is no requisition at all for 3A candidate. The question of sending 3A candidate,
that comes later. First, we have to ascertain whether he is selected under 3A or 3A rural.
But there is no 3-year rural.
ಈಗ
Only
ಇದು-
rural.
ವಕೀಲ್ರೆ
Please.
3A ಮಾತ್ರ ಇದೆಯೋ 3A ರೂರಲ್ ಇದೆಯೋ ಅದು ಒಂದ್ ಕಡೆಗೆ ಇಟ್ಟಿರೋಣ ಕೇಳುವ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ವಿಶ್ವನಾಥ ತಿಪ್ಪಣ್ಣ ಹೊಸದಿಯಾ ಅವ್ರನ್ನ ಯಾವ ಕೆಟಗರಿಯಲ್ಲಿ ಹೇಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೀರಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ.
ರೂರಲ್.
ಕೊಡಿ ಆ ಡಾಕ್ಯುಮೆಂಟು.
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲಲ್ಲ.
ನಾವು ಕೇಳಿದ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ನ ನೀವು ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಯಾವ ಕೆಟಗರಿಯಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿದಿರಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ.
ಶೀಟ್ ಇರುತ್ತೆ, ವರ್ಕೌಟ್ ಮಾಡಿರ್ತಾರೆ, ಆ ಶೀಟ್ ನ ತಗೊಂಡು. That's the only way I think I can
Oh,
able to satisfy.
No, that is what we wanted to see.
Please, I will calculate it because there is a rural only with what is the vacancies are only in rural. No question of I going back and anything else, stating anything other than that does not correct. Because vacancies are under rural only. First thing first.
Learned counsels from both sides are present. Learned counsel for there is respondent number 1 and respondent number 2 have filed a memo producing 2 documents on perusal of the same. It reveals that the first document is a communication made by Director Minorities Directorate to respondent number 2. And the second document is the Form 7 sent by Director Minorities Directorate Planning. We heard learned counsel for respondent number 2 for some time. And inquired with him about the document to be produced in respect of respondent selection of respondent number 3 in 3A rural category. And he seeks time for production of the same. Accordingly, time is granted till 16 to 4 to 4.
My lads, I'm sorry for the interference, my lads. My lads, serial number 71 to 75. I'm ready with the matter, my lads, due to network issue.
Serial number 40, Maitreyi Krishnan.
If statute is covered. The matter pertaining to transit the candidate. Challenging the recruitment to armed police constable manner.
Yes, please.
Section number of this honorable title before going forward to the arguments. The recruitment for the post of armed police constable reserved 68 posts for the category of transgender men. This comes under challenge in the instant applications manner. 7 identically placed applicants are before this court in a batch of matters. Broadly, 2 wings of this notification come to be challenged by the applicants. Firstly, my lord, was regarding the factum of reservation for transgender men, whereas 9(1)(d), my lord, clearly stipulates reservation for an others category. I had pointed out to my lordship on the last date of hearing that section 2K of the Transgenders Act contains as many as 9 to 10 subcategories, and a reservation for the post of transgender men fairly amounts to internal reservation, which is not contemplated in law. That was the first thing of challenge, my lord. The second thing of challenge was the failure to grant any relaxation, physical relaxations, to the applicants herein. The state's response in this regard, my lord, has been twofold. The first argument they make is that since this is the post of armed police constable, a higher level of physical efficiency is required. As such, they are making reservation only for the post of transgender men. Their argument, my lord, is higher physical efficiency is required. For civil police constable, they say, my lord, in their reply statement, that we have permitted transgender women and transgender men. But since this is armed police constable, which does not contemplate even reservation for women, we have provided only reservation for transgender men. At its very core, my lord, this reply argument suffers from a very deep lack of understanding of the entire concept of transgender candidates. Just as an example, my lord, a person who is born at birth is a female, my lord, might identify later as a transgender man. Her physical characteristics may be that of a woman. A person who's born as male, my lord, who later, my lord, comes to identify as a transgender woman, would have the physical characteristics of a man. Now, if we roughen their argument down to the fact, the poor argument made by them is we need strong people. That's the basis of the argument. Then the fact that they're saying they are having men and trans men, it makes no logical sense. But beyond the logical fallacy, my lord, it's totally unconstitutional, this action. To go forward, my lord, I have pointed out in my application about how various states have granted relaxations. On this point, my lord, the state's reply is that one person has qualified. They have produced, along with their reply statement, the appointment and qualification of one transgender person among 68 posts. Our submission, my lord, is that if only one person out of all of your applicants, you could only find one person to fill your 68 posts, that adequately shows that these kind of standards will not meet the criterion of adequate representation of this category of candidates. As such, my lord, on these 2 wings, we are seeking for interference at the hands of this honorable court. Before going into the facts of this case further, my lord, with the personal document, I take my lordship to the position of law by going to the citations on this point.
Yes.
I want to hand it. It was already partly argued before the predecessors, my lord. First volume of my lord takes up. The very first judgment, my lord, is the seminal judgment of the Supreme Court. In the case of Nalsa versus Union of India, in my memo itself, my lord, I've placed the propositions of each case which I'm placing reliance on, my lord.
Yes.
My lord, at the outset, the first judgment is an Nalsa judgment. Seminal judgment leading, culminating in the
Is it not your citation at serial number 6 alone is most material?
Please, my lord. That is material, my lord. May I point out to the relevant portion in that matter?
Yes.
It starts, my lord, at page 292. I refer, my lord, at page number 294, para 8 and para 10. The judgment of a single bench is the Honorable Calcutta High Court, my lord. Two 92, I refer 294, my lord.
Yes.
Para number 8. He refers to the directions in Nalsa, my lord. The directions in paragraph 135.2 and 135.3 are to the center state government. Such directions, in my view, would include an authority within the meaning of Article 12 of Constitution of India. Therefore, State Bank of India is bound by directive issued in Nalsa. That apart, a transgender is entitled to the right to participate in the selection process as a transgender. A transgender cannot be discriminated on the basis of sex. The selection process undertaken by FCI does not allow a transgender to apply as such as the gender column on the online application form provides for two options, which does not include a transgender. Such an online application form is an active discrimination against a transgender and is violative of Article 15 of the Constitution of India.
Yes.
Like difference in this case, my lord, is that only male and female categories were provided. In my instant case, transgender male was provided, whereas they fall within several subcategories, cultural subcategories, as defined in the Transgender Act. So that aspect which is also understood.
According to, it was sufficient only to mention transgender.
And all of us, my lord, as I had pointed out last year, all of us have a card issued under the Transgenders Act, issued by the DC, my lord, stating that identifying me as a transgender. But only transgender would be mentioned in terms of the act, because as found by the Constitutional Bench of the Supreme Court, transgender is an umbrella category. As soon as you do this internal reservation, my lord, in fact, what they do is they say that in their reply statement, they say transgender men, we are giving your male qualifications, physical qualifications, transgender women.
There is no force. You are generally treat as same when and all you yes. It is too difficult to say that we are men unless they have themselves. It is sensitive.
Yes.
My lord, may I request the court to go into a few of the paragraphs of the Nalsa judgment which are relevant for consideration. Of course, the Nalsa judgment is pre-passage of the 2019 Act. It's the way the Supreme Court interprets how transgenders are to be considered.
Sorry for interference. Nalsa judgment mandates that opportunity should be given to transgenders for recruitment. Here, opportunity is already there. Now, your contention is you have discriminated as transgender men and women. You talk about that.
Please, sir.
Nalsa judgment, we all of us know.
I won't take my logic through those points there. I'll only stick
Because time is important.
I understand, but don't want to waste the precious time. The only aspect in Nalsa which I sought to highlight was that the court comes to the conclusion that as soon as you are discriminating against transgenders, it amounts to a violation of Article 14, Article 15, Article 19, and Article 21 of the Constitution by substantially interpreting the rights of transgender persons. The contention here is this subcategorization by allowing for only transgender men. Similarly, amounts to a violation of the Article 14, 15, 19, and 21 rights of the applicants. Next, my lord, I won't again. I'll try not to have provided 3 volumes of citations. I won't take my lordship through all the citations. Just the propositions. My lord, after the Nalsa judgment and after the Transgender Act, my lord, no affirmative action was being provided. Sangama, my lord, NGO approaches the Honorable High Court and seeks for certain directions. During the pendency of those cases, my lord, 91D comes to be incorporated in the general rules, my lord, general recruitment rules. Now, the question before my thoughts, before this tribunal, is whether this classification of transgender men is a classification which can be upheld under Article 14.
Okay, sorry again. General recruitment rules are there. Now 9D is already incorporated. There are special rules of cadre and recruitment rules for police. You talk about that. The authorities will go according to special rules.
My lord, in fact,
Cadre and recruitment rules of a particular department.
as I pointed out to my lordship, with the include notification, I take my lordship again to the include notification then, since my lordship is asking me this question. The include notification also places reliance on the general recruitment rules as amended from time to time, which means, my lord, that the
Not only 9D,
not only
all clauses.
all clauses, which means, my lord, that 91D, my lord, would equally be applicable to this recruitment rules as well, since specific reliance is placed on the general recruitment as amended
Okay,
from
next.
time to time. Yes. Shall I, my lord, then conclude the arguments on factual aspects before going into the question?
We are aware of factual aspects.
May I take my lordship there to the arguments on granting of relaxations to these transgender candidates? I have sought, my lord, to place reference only by their persuasive value to certain relaxations granted by other recruiting authorities in other states, my lord. Those documents have been placed on record by way of memos. In fact, original copies have been placed along with the application, but they were in Hindi and some reference of Tamil was there, produced translated copies by way of memo dated 30/10/25 and 21/11/25. My lord, recruitment for the post of constable in Bihar.
Which constable? Armed police constable or
It's called prohibition constable, my lord. Prohibition constable.
prohibition constable is only for excise.
Yes.
They have a separate wing because there is a prohibition in Bihar.
I refer page 5, my lord. Subclause Roman 4, bottom of the page, my lord. My lordships have found it. For female, Koti, Hijra, and transgender, third gender. As per clause 5 of resolution 386 dated so of Government of Bihar, the physical standards and physical efficiency test standards for transgender candidates will be the same as for female candidates of backward classes. Then, my lord, the next memo is in respect of the Home Police Department of Tamil Nadu. And refer at page number 5, my lord, last page of the memo. From Post of Tamil Nadu Police Subordinated Services and para 8, my lord. Government has carefully examined the proposal of GTP head of police. 7 read above. It observed that both certain privileges have been made to the welfare of transgender candidates. The observations made by the Honorable High Court Madras is further fixed read above. For the upliftment of transgender candidates has been considered, and accordingly, in compliance with the observations of the Honorable High Court Madras, so government hereby directs that the third gender candidates shall be granted age relaxation similar to age relaxation as provided to scheduled caste and scheduled tribe candidates for the recruitment throughout Tamil Nadu. The reason I refer to this, my lord, is I'll read out the judgment in Aradhana of the Madras High Court.
See, the age relaxation is different than the relaxation in physical standards. You are seeking relaxation in physical standards. It's not comparable.
The reason it's comparable, my lord, is that the Honorable Court says that all relaxations to ensure substantial accommodation, my lord, all relaxations have to be provided, which is why I refer only for persuasive value. Then, my lord, I'm filing a memo with certain other newer documents, my lord. The first document, my lord.
1 minute. Except serial number 5 and 6, the other documents you are supposed to file along with IA. Yes. By a memo, you cannot file it. Other side should have an opportunity to meet the contention taken in those documents and the relevancy of those documents.
Continue with the arguments and those documents are placed the memo on the next with an idea on the next subject, my lord.
And then unless the documents are permitted to be produced, you cannot rely upon them.
Please, my lord, I'll continue with the other arguments. I'll produce it with an application.
You come up fully equipped in all respects.
I have.
What is the office?
Since from both sides of the case, we referred the learned counsel for the applicant for some time. And after hearing the learned advocate seeks time to produce certain documents through interlocutory application. Praise for time.
Produce document interlocutory application has ready. By making certain submissions, she prays for time.
Time has
it is granted.
17-2.
17-2. Serial number 41.
Maruti and Associates. Pertains to murder. The authorities will be sending into medical test.
Hearing deficiency.
Yes. But only murder, repetition of other statement murder matter is posted today or earlier also murder. But they want to produce memo murder. It's similar set of facts and one person was including this proceeding murder. She has filed petition before the before the murder with the direction. And sentence is the murder. Letter issued by the authorities. Home and daily is not a place treatment paid by the opponents. The one who is not Archana Rina, she is the fundings of this. That is 7. Carrot 10 minutes. Page number 10, carrot 10.
Carrot?
Carrot 10. Page number 10. He was also issued a letter to appear the principal test. Earlier, she refused. Subsequently, actually, as not attended medical test, submitted for the authorities. Once again, they are issued notice to Mlad attend medical test before the adult evaluation test, Mysore. That has been challenged them in blood application Mlad before Stumner. That has been displaced. Subsequently, approved the Mlad challenging the order of the Stumner before the that has been disposed. But and passed that data and other data have been issued. Same question here. And some more than replace statement. 7 members have been issued notice. The replace statement R2, they have produced the document one. There is 932 and 23. R2 page number 1. Oh, replace statement. There is another A2. R2.
No, what is the dictum of the Honorable High Court in this WP?
Yes, ma'am.
She challenged the
Same.
order of she being called for the
Yes.
test once again.
Yes.
She remained absent.
Yes.
One time she appeared
Yes.
and she was expected to produce some medical
Yes.
records pertaining to her.
Yes.
She did not produce them.
Yes.
As such, that became inconclusive.
Yes.
And the second time, in the year 2023, she was called again.
Yes.
She did not appear on the ground of ill health.
Yes.
On the ground of ill health. Yes. What was the direction of the Honorable High Court?
The direction is with the part of charts from panel 11. This court finds considerable force in these officials of Sri Vikas Rojipura that if intended petitioner does not suffer from hearing impairment but has contrived certificate to that effect would tantamount to securing employment by improvised means
Therefore, the respondent therefore must be at liberty to avail remedy for permitted in law, but subject to all just exceptions and without prejudice to the petitioner defense, and that would be available in the event such proceedings are intended. As such, the following: the petition is allowed quashing the impugned notice dated 24/2023 under A11 and tribunal's order dated 17/11/2023 in application number 1485/2023 under A, but with liberty to the authorities for opposite and without prejudice to the petitioner defense, if in case such remedy is available.
What we should understand
Yes.
by paragraph number 11 and the operative portion of the order.
In my case,
No, what we have to understand by reading this.
but idರಲ್ಲಿ they have quashed the letter issued by the authorities to attend the medical test, and subsequently the liberty has given result to the authorities to take appropriate action. They can file appeal, not appeal, they challenge the certificate only. They cannot send frequently to attend the medical test.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ?
ಇದರಲ್ಲಿ take
ನೀವು ಓದೋದನ್ನ ಬೇರೆ ಓದಿ ನಿಮ್ಮದೇ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಕೊಟ್ರೆ
and page number 9.
ಆ 9 ಎಲ್ಲದೂ ಹೋಗ್ತದೆ ಹಿಂದೆ. ಪ್ಯಾರಾ 11 ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಷ್ಟೇ ಮೆಟೀರಿಯಲ್,
Yes.
ಅದಷ್ಟೇ ಮೆಟೀರಿಯಲ್. ಅದರಿಂದ ಏನ್ ಅರ್ಥ ಆಗ್ತದೆ ಹೇಳಿ?
Para 11 ಅಲ್ಲಿ ಮಾಡೋದು
ಪ್ಯಾರಾ 11 ಇಂದ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಇನ್ಫರ್ ಆರ್ what the Honorable High Court intends to say or intend to communicate to the reader.
Intent by imprisonment meanly they are taken appointment. If they want to question the certificate, they challenge the certificate. Without challenging certificate, so they cannot send the ignorant again to medical test.
ಆ ಸೆನ್ಸ್ ಬರ್ತದೇನ್ರಿ ಅದು ಓದಿದ್ರೆ?
Meaning of after going to this all the facts and circumstances, this is the meaning. Adal para 8 is very clear. Para 8 para number 9.
Government reply is not taken is taken as not filed. So you don't. Our nimuk ಕೊಟ್ಟಿರಬಹುದು, but ಇಲ್ಲಿ tribunal has taken it.
2 times ಕೊಟ್ಟಿದ್ದಾರೆ. That's why last occasion ಕೊಟ್ಟರಲ್ಲ,
it is taken as not filed. ಅದನ್ನ ರೆಫರ್ ಮಾಡಬೇಡಿ. We are not considering it.
In my case, they want to bring facts. My case, the applicant earlier attended the medical test. The medical board also issued some opinion as per Anachar A5 page number 16.
No, whether the Honorable High Court in the case which you have filed had stated that the All India Institute of Speech and Hearing, the applicant or the writ petitioner ought not to have been referred to All India Institute of Speech and Hearing ಅಂತ ಹೇಳಿದ್ದಾರ ಅವರು? ಹೇಳಿಲ್ಲ. 2 ಸರ್ತಿ ಅವ್ರನ್ನ ರೆಫರ್ ಮಾಡಿದ್ದು ರಾಂಗ್ ಅಂತ ಹೇಳಿದ್ದಾರ? ಹೇಳಿಲ್ಲ. ಮತ್ತೆ
why I am producing this she is also part of the proceedings. Total 7 members have been initiated the action. In that the petitioner also one of the person in that proceeding. That's why I bring the notice on problem. But in my case, not the applicant appear for the medical test, and also medical board also not issued this and
did you appear before the All India Institute of Speech and Hearing?
All India Institute of Speech and Hearing I am not attended.
That is the point.
That letter I will question people is to not that is stay at granted.
ಅದೇ ಪ್ರಶ್ನೆ ಇಲ್ಲಿ ಇರೋದು. ಇದರಲ್ಲಿ ಆಕೆಗೆ 2 ಸರ್ತಿ ಆಲ್ ಇಂಡಿಯಾ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಸ್ಪೀಚ್ ಅಂಡ್ ಹಿಯರಿಂಗ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ನನ್ನ ಕೇಸಲ್ಲಿ
ಈಕೆ ಒಮ್ಮೆ ಹೋಗಿದ್ದಾಳೆ, ಹೋಗಿ ಇನ್ಕಂಪ್ಲೀಟ್ ಟೆಸ್ಟ್ ಆಗಿ ವಾಪಸ್ ಬಂದಿದ್ದಾಳೆ. ಇವಳೇ ಕೊಡ್ಬೇಕಾದ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಮ್ಮೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಮ್ಮೆ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಈಕೆ ಹೋಗ್ಲಿಲ್ಲ.
In my case,
ಹೋಗದೇ ಇದ್ದಾಗ ಬರ್ಲಿಲ್ಲ ಅಂತ ಆಯ್ತು. ಆ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾಳೆ ಆಕೆ.
In my case,
ಅದಕ್ಕೆ Honorable High Court has not found any fault with asking her to undergo a test at AISH.
Yes.
He did not say that she ought not to have been, he or she ought not to have been referred to AISH. ಹಾಗೆ ಹೇಳಲಿಲ್ಲ.
However, letter has been
ಇನ್ನು ಅವರಿಗೆ ಆಪ್ಷನ್ ವೈಡ್ ಓಪನ್ ಇಟ್ಟಿದೆ.
Yes. However, letter has been passed. But my submission is that in my case, the applicant appear.
ಅಲ್ಲಿ ಲೆಟರ್ ಕ್ವಾಶ್ ಆಗ್ಲೇಬೇಕಂತಿಲ್ಲ. ನಾವು ಅದಕ್ಕಿಂತ ಒಂದು ಹೆಜ್ಜೆ ಮುಂದೆ ಹೋಗ್ತೇವೆ. ಲೆಟರ್ ಕ್ವಾಶ್ ಆದ್ರೆ ವಕೀಲರಿಗೆ ಇನ್ನೊಂದ್ಸರ್ತಿ ಫೀಸ್ ಬರ್ಲಿಕ್ಕೆ ಒಂದು ವಕಾಲತ್ ಸಿಗುತ್ತೆ ಅಷ್ಟೇ. ರಿಪೀಟೆಡ್ ಕಾಸಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬರ್ತಾ ಇರ್ತದೆ.
In my case,
ವಿತ್ ಆಲ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಹೇಳ್ಬೇಕಂದ್ರೆ ಎಷ್ಟೋ ರಿಟ್ ಪಿಟಿಷನ್ಗಳು ಹಂಗೆ ಆಗ್ತಾವೆ. ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗ್ತದೆ, ವಾಪಸ್ ಮತ್ತೆ ಅಲ್ಲೇ ಕಳಿಸು, ಮತ್ತೆ ಹೊಡೆದಾಡ್ಲಿ, ಮತ್ತೆ ಬರ್ಲಿ, ಮತ್ತೆ ವಾಪಸ್ ಕಳಿಸು, ಡಿಸ್ಪೋಸ್ ಆಗ್ತಿರ್ತದೆ. ಬೇಡ, ಒನ್ ಫಾರ್ ಆಲ್ ನಾವು ಫೈನಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡೋಣಂತೆ.
just for bringing notice, madam, I will produce the document.
ಆಗ್ಲಿ, ಇದು ನಿಮಗೆ ಹೇಗೆ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ ಅಂತ ಕೇಳ್ತಿದ್ದೇವೆ ನಾವು.
ಯಾಕೆ ಆಗ್ತಿದೆ ಅಂದ್ರೆ ಆಫ್ಟರ್ ರಿಸೀವಿಂಗ್
ಈಗ ನಾವು ಹೇಳೋ ತರ ನೋಡಿದ್ರೆ ಇದು ನಿಮಗೆ ಎಗೇನೆಸ್ಟೇ ಆಗ್ತದೆ ಅಲ್ವೇ?
But ಯಾಕೆ ಆಗ್ತದೆ ಅಂತಂದ್ರೆ in the request statement they also produce the document including that petitioners. That's why bringing notice. A request statement ಅಲ್ಲಿ ಆ ಲೆಟರ್ ಅಲ್ಲಿ there are 7 members who are referred, who are directed to attend medical test. The petitioner also one of the person. That's why bringing notice. In my case, the applicant appeared before the medical test. The medical board also issued the Vaidike Abhipraya. In that, they are clearly stated the applicant having disability. But after receiving that recommendation, once again he has not directed to appear medical test. That has been challenged this after lapse of 12 years.
Without prejudice, there is also an observation by Honorable Supreme Court in similar cases. If the candidate does not have any apprehension about his or her disability, what prevents her from going before the medical board once again?
But my submission,
This is an observation of Supreme Court.
Is that but he is appointed in the year of 2012, the probation period also declared, while issue declaring probation period, they have checked out all the documents which are produced by the applicant only time of the appointment. But that is only one of document is that not a disability certificate. They cannot challenge disability certificate at all. They are not at liberty to challenge the disability certificate before the appropriate authority under the Disabilities Act. But they are not challenging that. They are simply sending the applicant to appear medical test frequently. This aspect, manner of the aspect, clearly prejudiced.
Yes, respondents.
22, the included orders.
Yes.
ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ ಮತ್ತು ಇತರೆ 6 ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿಗಳ ಜೊತೆ ಕಲಿಯ ಅಂಗವಿಕಲ ದಾಖಲಾತಿ ನೀಡಿ ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಸಲ್ಲಿಸುವುದಾಗಿ ಸ್ವೀಕೃತವಾದ ದೂರಿಗೆ ಗಮನಿಸುತ್ತೆ. ಸದರಿ ನೌಕರರನ್ನು ಅಖಿಲ ಭಾರತ ವಾಕ್ ಮತ್ತು ಶ್ರವಣ ಸಂಸ್ಥೆ ಮೈಸೂರಿಗೆ ವೈದ್ಯಕೀಯ ತಪಾಸಣೆಗೆ ಹಾಜರುಪಡಿಸುವಂತೆ ಹಾಗೂ ಹಾಜರುಪಡಿಸಲು ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕದ ಮಾಹಿತಿ ಮತ್ತು ಜಿಲ್ಲಾಧಿಕಾರಿ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುತ್ತಾರೆ. ಸಿದ್ದಪ್ಪ ಗ್ರಾಮ ಆಡಳಿತಾಧಿಕಾರಿ ಇವರನ್ನು ಅಖಿಲ ಭಾರತ ವಾಕ್ ಮತ್ತು ಶ್ರವಣ ಸಂಸ್ಥೆ ಮೈಸೂರಿಗೆ ವೈದ್ಯಕೀಯ ತಪಾಸಣೆಗೆ ಹಾಜರುಪಡಿಸುವ ಸಂಬಂಧ ಈ ಸರ್ಕಾರ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಅಧಿಕಾರಿಗಳಿಗೆ ನಿಯೋಜಿಸಿ ಆದೇಶಿಸಿದೆ. ಜಿಲ್ಲಾ ಕಲ್ಯಾಣಾಧಿಕಾರಿ ಜಿಲ್ಲಾ ನಾಗರಿಕ ಸ್ಥಳೀಕರಣ ಇಲಾಖೆ ಮೇಲ್ಕಂಡ ಅಧಿಕಾರಿ ದಿನಾಂಕ 9/11/24 ಸಿದ್ದಪ್ಪ ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ ಗುರುವಾರ ವೃತ್ತ ಕಡೂರು ತಾಲೂಕಿನ ಅಖಿಲ ಭಾರತ ವಾಕ್ ಮತ್ತು ಶ್ರವಣ ಸಂಸ್ಥೆ ಮೈಸೂರಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ತಮ್ಮ ಸಮ್ಮುಖದಲ್ಲಿ ವೈದ್ಯಕೀಯ ತಪಾಸಣೆ ಒಳಪಡಿಸಿ ಮಧ್ಯಾಹ್ನ ಪರೀಕ್ಷೆ ಪ್ರಚರಿಸಲು ಸೂಚಿಸಿದರು. ಈ ರೀತಿ based on the complaints received by the general public. There is no prejudice to go and appear before the committee.
No, you argue the matter as a counsel is expected to argue. Merely because a complaint comes, can you, at your whims and fancy and in a manner which you like, you keep on referring the person to medical test, this step, that probe, anything or everything, or do you have any parameters or the framework of a law, procedure, rules and guidelines as how you have to deal with those type of complaints? ನಕಲಿ ಅಂಗವಿಕಲ ಪತ್ರವನ್ನು ದಾಖಲಿಸಿ ಅವರು ಉದ್ಯೋಗವನ್ನು ಪಡೆದಿರುತ್ತಾರೆ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇ ನಿಮ್ಮಲ್ಲಿ ನಾನೊಬ್ಬ ಇದ್ದೀನಿ, ನಾನೇನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು, ಕಳಿಸಿರಿ ಅವನು ಅಲ್ಲಿಗೆ ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ, ಇನ್ನೊಂದ್ಸಲ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬರಲಿ, ಹಾಗೆ ಮಾಡಬಹುದು. ಅದಕ್ಕೆ ಏನಾದರೂ ಕಾನೂನಿನ ಇತಿಮಿತಿ ಚೌಕಟ್ಟು ಇದೆಯೋ? ಆ ಕಾನೂನಿನ ಚೌಕಟ್ಟು ಏನಿದೆ ಅನ್ನೋದನ್ನ ನಮಗೆ ಫಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ ಆಮೇಲೆ ಹೇಳಿ. ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಮ್ಮ ಕೋಠಾನಲ್ಲಿ ಒಂದು ಪದ್ಧತಿ ಉಂಟು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನ ನಾವು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ತೇವೆ, ಅಥವಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲಿ ವರ್ಬ್ಯಾಟಿಮ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ತೇವೆ, ಅದನ್ನ ಆರ್ಡರ್ ನಲ್ಲಿ ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇವೆ. ದಿಸ್ ವಾಸ್ ದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ. ಹಿಂದಿನವ್ರಿಬ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಂಡು ಹೋಗು. ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. ಈ ರೀತಿ ಕಂಪ್ಲೇಂಟ್ ಬಂದಾಗ, ಡಿಸೇಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟು ಬೋಗಸು ಫೇಕು ಅಂತಾದಾಗ, ಎಂಪ್ಲಾಯರ್, ಗೌರ್ಮೆಂಟ್, ಅಪಾಯಿಂಟಿಂಗ್ ಅಥಾರಿಟಿ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಏನೇನು ಮಾಡಬಹುದು, ಇದರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದೀರಿ, ಏನೇನು ಮಾಡಬಹುದು ಅನ್ನೋದನ್ನು ಎಷ್ಟು ಸರ್ತಿ ಮಾಡಬಹುದು ನೋಡ್ಕೊಂಡ್ರೆ. ನಮ್ಮ ಕೋರ್ಟಿನಲ್ಲಿ ಹಾಗೆ ಹೀಗೆ ವರ್ಷಿಯಾಗಿ ಪಕ್ಕದಲ್ಲಿ ಇಡಂತದ್ದು ಆಗಬಹುದು. And counsel from both sides present heard the further argument of learned counsel for the applicant in full. Learned AGF for respondents prays for some time to address his argument. Time as period is granted, list the matter on ಯಾವ ಕೊಡಬಹುದು. 18 to 18 next month or ಅವ್ರು ಮರ್ತು ಬಿಡ್ತಾರೆ, ನಿದ್ದೆ ಮಾಡ್ತಾರೆ. ಫ್ರೈಡೆ 27/1 ಎಂಟ್ರಿ ಮಾಡೋ ಗ್ರಾಂಟೆಡ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ರೇಟ್ ಇಲ್ಲ.
27/1
Yes. Next matter
serial number 42 Arpina Murthy P.
Yes. For respondent. Depends. Government aided school. He applied for hospital warden, hostel superintendent, backward process and law. Backward process welfare department. For hospital superintendent. Eligibility criteria is mentioned in the connection A1. Page number 10 meter. Page number 10, round number 5 minutes. For insurance candidate, page number 1 must be a holder of the degree with the degree in education. Second, must have put in a service not less than 5 years in the cadre of second university. Ashama school teachers, typists, drivers, cooks, kitchen servants, and fields in the Karate Backward classes welfare department. Yes. Applicant is choosing aided school as a assistant teacher, English teacher. He has not fulfilled the eligibility criteria as mentioned in the notifications. Yes. Does not fulfill the criteria as described in your notification. Then application is considered open competition. Open competition. He scored in the open competition 49.75%. He is not at all coming in the cutoff marks in the open competition. Yes. And there is related. Finally, is it? Yes, it will say. Any reply?
That they are not considered as a presentation. Lecture be 7 minutes.
Platform from both sides present. All respondents are given. Followed by reflect. Orders result.
Let's one submission, let's. The other matter that can I take an adjunct remaining part?
Then why did you say ready this morning? Because that is the part-head matter, the Supreme Court direction, everybody know.
Covered against me.
ಅಂತದಿರೋ ದಿವಸನೇ ಎಲ್ಲರೂ ರೆಡಿ ಅಂತಾರೆ. ಇದು 60 ವರ್ಷದ ಮುಂಚೆನೂ ವಕೀಲರು ಇದನ್ನೇ ಮಾಡ್ತಾ ಇದ್ರು. ಹೊಸ AI ಬಂದಿದೆ, ಹೊಸದೇನಾದ್ರೂ ಹುಡುಕಿ. ಹಳೆ ಟ್ರಿಕ್ಗಳನ್ನ ಎಲ್ಲರೂ ಮಾಡ್ತಾವ್ರೆ, ನಮಗೆ ಊಟ ರುಚಿಸಲ್ಲ. ಹೊಸತನ ತಗೊಂಡ್ ಬಂದ್ರೆ we enjoy the dishes.
Covered against me, it is already apex court in co-applicant's case has held against him. He also admits it. Our ground bench
Highly concedes it.
As a dispose ಆಗುತ್ತೆ ಅದು. First hearing matter. Started for the argument ಬೇಕಾಗಿಲ್ಲ. Once that he admits that it is co-applicant, unsettled, you cannot unsettle the position of seniority. ಆ ground ಮೇಲೆ Supreme Court hold ಮಾಡಿದೆ. So the fact that the judgment covered again. Therefore, I'm saying started.
I appear for the respondents in that case. I have produced the judgment.
What is there to argue?
ಏನಾರ ಅದೃಷ್ಟ ಇದ್ರೆ ಒಂದ್ ವಾರದೊಳಗೆ ಇನ್ನೊಂದೇನಾದ್ರೂ ಬಂದ್ರೆ, ಇನ್ನೊಂದೇನಾದ್ರು ಜಜ್ಮೆಂಟ್ ಅವ್ರ ಕೈಗೆ ಸಿಕ್ಕರೆ, ಈ ಪ್ರೊಫೆಷನಲ್ ಅದೊಂದು ಇದೆ ಅಲ್ವೇ, ಲಕ್ ಅನ್ನೋದೊಂದು ಫ್ಯಾಕ್ಟರು ಅಷ್ಟೇ. Learned concepts from both sides present. Learned concept for the applicant. Praise for a short accommodation. List the matter on 21.
Similarly, serial number 51, 68, 69 also.
Similar matter,
ಇಲ್ಲ similar ಅಲ್ಲ, ಅದು covered against that. Two distinguished ಮಾಡೋ ಅವಕಾಶ ಇದೆ. Date.
ಸೇವ್ ಮಾಡಿ ಡೇಟ್ 5/2 ಹಾಕಿ 68/16.
5/2 serial number 50 ಅಲ್ಲಿ ಒಂದು SC/ST ಪ್ರಮೋಷನ್ಸ್ ಜನರಲ್ ಇಂದ ಬಂದಿದ್ದವ್ರಿಗೆ ರೂಲ್ಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು, ಮತ್ತೆ ಡೈರೆಕ್ಟ್ SC ಇಂದ ಇದ್ದವ್ರಿಗೆ ಪ್ರಮೋಷನ್ ವಿಷಯವಾಗಿದೆ. I do need to
ಬೆಳಗ್ಗೆ ಹೇಳ್ಬೋದಿತ್ತಲ್ವೇ, ಜನವಾಡಿ ಅವರು ಬೆಳಗಿಂದ ಕಾದ್ರೆ
there was some circular, some clarification memo. Then later I came to know that was rejected by this court. That's why I need to obtain further.
Same 5/2 ಮಾಡಿ 5/2.
5/2.
Let's serial number 71 to 75. Due to my fault, let's
the dismiss ಆಗಿದೆ.
kindly have this matter tomorrow, let's. I will argue the matter.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ರೀ ಇದು.
Kindly restore and post this matter tomorrow, my lords. Due to internet error, my lords, I was unable to.
ಅದು ನಿಮ್ಮ ರಿಸ್ಕ್ ಅದು.
It's my fault. It's my fault.
That is a risk. ಇದನ್ನ ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿಯೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ, ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಹೇಳಿದೆ, ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದೆ.
I am very sorry, my lords.
ನನಗೆ ಲೈನ್ ಸಿಕ್ಲಿಲ್ಲ, ಇಂಟರ್ನೆಟ್ ಸಿಕ್ಲಿಲ್ಲ, ಇನ್ನೊಂದೇನೋ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದು ಅಡ್ವೊಕೇಟ್ಗಳ ರಿಸ್ಕ್ ಅದು. ದೇ ಕೆನಾಟ್ ಬ್ಲೇಮ್ ದಿ ಕೋರ್ಟ್ ಅಂತ.
I am sorry, my lords. Have this matter tomorrow, my lords. I will argue the matter.
ಈಗ 71 to 75 ಬೆಳಗಿನ ಟೆಕ್ನಿಕ್ ಮಾಡಬಹುದು. Both side percent. Let counsel for the applicant appear through video conferencing, citing some personal inconvenience, praise for a time. Perusal of the order sheet would go to show that several and sufficient opportunities, even as finally and last chance, have all been granted to him. However, considering the reason shown by him, ಫೀಸ್ ತಗೊಳ್ಳೋದು ನೀವು, ಇಲ್ಲಿ ನಿಮಗೆ ಸುಳ್ಳು ಕಾರಣ ಹುಡುಕದ್ ನಾವು.
I am sorry, my lords. I appeared in first matter.
ಎಷ್ಟು ಪಾಪ ಬರ್ತದೋ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ.
I am sorry.
However, considering the reason shown by him,
As an ultimate opportunity, a short accommodation as paid is granted. Sixteen, 12, 16-2.
16-2.
Very grateful.
Serial 64, my lord. 64.
ಒಬ್ಬರಿಗೆ ಒಂದು
64, my lord.
64
got some inconvenience in the afternoon, my lord. In fact, I sought for Passover.
ಒಂದು ಸೈಕ್ಲೋಸ್ಟೈಲ್ಡ್ ಫಾರಂ ಇಟ್ಕೊಳ್ಳಿ, ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ. ಈ ದಿನ ನಾನು ನನ್ನ ಮೊಕದ್ದಮೆಯನ್ನು, ನನ್ನ ಅರ್ಜಿಯನ್ನು ವಾದ ಮಂಡನೆಗಾಗಿ ಮೀಸಲಿರಿಸಿದ್ದು, ಕಾಯ್ದಿರಿಸುವಂತೆ ಕೋರಿಕೊಂಡಿದ್ದು, ಅದು ದಿನದ ಕರ್ತವ್ಯದ ಅವಧಿಯಲ್ಲಿ ಯಾವುದೇ ಹೊತ್ತಿಗೆ ತೆಗೆದುಕೊಂಡರೂ ನಾನು ನನ್ನ ವಾದ ಮಂಡಿಸಲು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ ಅಂತ ತಗೊಳ್ಳಿ ನಾಳೆ. Then why do you repeatedly give us the labor of, say, giving dictation twice in every matter? Let counsel from both sides present. Let counsel for the applicant praise for time. As a last chance, time as paid is granted. List the matter on 17-2.
17-2.
46. 40? 46. 40. 46 ಅದರ್ ಸೈಡ್ ರೆಡಿ ಅಂದ್ರಲ್ರಿ. ಯಾರು ಬಾಲಾಜಿ ಯಾರು ಅಲ್ರಿ? ನೀವು ಅದೇ ಆಫೀಸ್ ಅಲ್ವೇ? ಪ್ರಾಕ್ಷಿ ಕೌನ್ಸಿಲ್ ನೋಡಿ, ಅವ್ರು ಹೇಳಿ ಹಿಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಕೇಳಿ ಅವ್ರನ್ನ, ಕೊಡಬಹುದು ಟೈಮ್ ಅಂದ್ರೆ ಕೊಡೋಣ ಅಂತ. ವಿ ಆರ್ ರೆಡಿ. ಆಸ್ಕ್ ಹಿಮ್, ಬಿಕಾಸ್ ಸೇ ಟ್ವೈಸ್ ಈಸ್ ಟೆಲ್ಲಿಂಗ್ ದಟ್ ಹಿ ಇಸ್ ರೆಡಿ. ಆಟೋ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ, ಆಟೋ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ 4 weeks ಟೈಮ್ ಕೇಳಿದ್ರು. ಅಲ್ರಿ ವಕೀಲ್ರಿ, ನಿಮ್ಮ ಕೋರಿಕೆಯನ್ನು ಮನ್ನಿಸಲು ನಾವು ಸಿದ್ಧರಿದ್ದೇವೆ. ನಿಮ್ಮ ಎದುರು ಪಕ್ಷದಾರರು ವಿರೋಧಿಸುತ್ತಿದ್ದಾರೆ. ಮತ್ತಷ್ಟೇ. ನೀವು ಆ ಕಡೆ ತಿರುಗಿ ಒಂದು ಸ್ಮೈಲ್ ಕೊಟ್ರೆ ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತಾರೆ. ನೀವು ಅದನ್ನ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾಕೆ ಎಷ್ಟು ಮಾಡ್ತೀರಿ? ಹೋಗಿ ಅವ್ರು ಬಾಲಾಜಿ ಅಸೋಸಿಯೇಟ್ಸ್ ಕಾಣಿಕೆ ಹಾಕಿದ ವೆಂಕಟೇಶ್ವರ ಯಾವತ್ತಾದ್ರೂ ಇದು ಬಿಡ್ತಾನೆಯೇ? ನೀವೊಂದು ಸ್ಮೈಲ್ ಕೊಟ್ರೆ ಸಾಕು, ಅದು ಕಾಣಿಕೆ. ಎಸ್, ತಮಾಷೆ ಮಾಡಿದೆ, ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಎಸ್, both side present. Counsel for the applicant. Both side present. Counsel for respondent number 5. Praise for time. As a final opportunity, time as paid is granted. 17-2.
17-2.
In that, I need to file an application also for the calling of the order.
ಏನ್ ಸ್ಟೇಜ್ ಇದೆ? ಅದ್ರಲ್ಲಿ ಏನು ಡೈರೆಕ್ಷನ್ ಇದೆ ನಿಮಗೆ? ಅಲ್ವೇ ಪೇಜ್ ನಂಬರ್ 105 ಮಿಸ್ ಆಗಿದೆ ಅಲ್ವೇ? ಇನ್ಕಂಪ್ಲೀಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದಿರಿ ಅಲ್ವೇ? ನಾನ್ ನೆನ್ಪಿಟ್ಕೊಳ್ತೇನೆ, ದಿವಸಕ್ಕೆ 200 ಕೇಸ್ ಮಾಡೋನು. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಕಾಸ್ಟ್ ಎಷ್ಟು ಹಾಕ್ಬೋದು ಅಂದ್ರೆ 1000 rupees ಮೈಲಾರ್ಡ್ ಅಂತೀರಿ. ಪಾನಿಪುರಿ ಎಷ್ಟಪ್ಪ ಪ್ಲೇಟ್ ಅಂದ್ರೆ ರೇಟ್ ಹೇಳಿದಂಗೆ ಮಾಡ್ತೀರಿ. ಕಾಲ್ಡ್ ಅಗೇನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪ್ಲಿಕೆಂಟ್ prays for a short accommodation to complete the direction. ನಿಮ್ಗೂ ಬೇಕೇ ಟೈಮ್ ಇದರಲ್ಲಿ? ಟೈಮ್ ಆಸ್ ಪ್ರೇಡ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್. ನಿಮ್ಮದಿನ್ನೂ ಆ ಶಾಸ್ತ್ರಗಳಿದೆ. ನೀವು ಶ್ರೀಮಂತದಿಂದ ಶುರುವಾಗೋರು ನಾಮಕರಣಕ್ಕೆ ಆಗ್ಲಿ. Leads the matter on 27-1.
27-1.
ಕೊಟ್ಟವ್ ಸರ್, ಕೊಟ್ಟವ್ ಸರ್. 64ನೇದು ಏನ್ ಕೊಟ್ರು ಸಾಹೇಬ್ರು ಡೇಟು?
17-2.
What up, sir?
17-2, sir.
17-2.
Hello.
Court officer. Court officer. Court officer. ಕೋರ್ಟ್ ಆಫೀಸರ್ 71ರಿಂದ 75 ಐದು ರೆಸ್ಟೋರ್ ಆಯ್ತಲ್ವಾ?
16-2, sir.
ಐದು ಅಪ್ಲಿಕೇಶನ್ ಆಯ್ತಲ್ವಾ? ಥ್ಯಾಂಕ್ ಯು.
Yes.
Both sides present. You are counsel for applicant praise for claim. List the matter on 18
18-2. Additional list for further arguments. Serial number 1, Bhagavat Associates on connected matters. KV Dhananjay Associates. PS Rajgopal Associates.
ಹೇಳಿದೆ ನಮ್ಮ ಪ್ರಕಾರ ಜೋಡಿಸಿದ್ದೀನಿ ಅವನು ನಾನು ಅನ್ನೋದಲ್ಲ ಹೇಳಿದ್ರು ಈ ಕಡೆ you can see him. Oh, probably you will come. Connected already. Both of you. ಬೇರೆ ಎಲ್ಲ ಮುಗ್ದಿದೆ ಹೌದು 4701 ಆಯ್ತು ಇದು 4707 Yes, please. Here for the contesting respondent to 4701 is not application number. There is a second of the. Not I will broadly state. Firstly, the applications are not indicated for the reason that recruitment notification categorically stated that the certificates for registration for the line reservation have to be submitted in accordance with the reservation rules as amended in the year 2000. Then what happened was the recruitment notification internally are stipulated that it should be in accordance with Rule 2000, which made a candidate claiming reservation and OBC categories 2 and 3. They have to submit if they are a married women candidate. Applicate certificate in Form F, which is what is prescribed by the reservation. Though they refer to as Government Order of 2000, that is a wrong statement in the sense. 2000 Government Order is amendment of the 1992 rules. It is a statutory rule, but they referred as Government Order source. They submitted the income certificate of their parents instead of Form F. Form F they no doubt. There instead of the husband, they said parents. Naturally, the
protocol for consideration of the candidates is, if claim of reservation is not backed by a required certificate, they will be categorized as general candidates. And they were called for, their merit was assessed, written examination. Their merit was assessed on the basis that they are general candidates. They neither questioned the recruitment notification at the threshold, nor made any protest stating that for a married woman also, parents' income will have to be taken. Your application is, your recruitment notification says, I have to submit the income certificate regarding taking into account the income of my husband. This is contrary to law. Without prejudice, I am filing such that application. No such tremor was expressed. No liberty was reserved. For the first time, they rushed to the court after publication of the select list, provisional select list, in which they did not find their place. They find their name. There, even when they approached the court, belatedly, no challenge was raised to the recruitment notification. Only thing is, they did not challenge any rule. They did not challenge the recruitment notification. All that say is that no, for married women, parents' income has to be taken whether married or not married. In the absence of their submitting to the recruitment notification without protest, without approaching the court, and after the provisional select list is made and published, even then not challenging any rule or notification, because recruitment notification also they did not challenge. This application, which are in the nature of taking benefit of part of the advertisement and questioning other part of the advertisement, that too belatedly, it cannot be counted. The application will have to be dismissed as not contestable. That will be my first submission. Second submission is about the word in the government order that they have applied, that is of 2004, 30th March 2004. 2002. It is not parents' income alone that is mentioned. There is an alternative in the government order itself. Parents or guardian. This word guardian becomes very relevant in as much as all the earlier orders, whenever they refer to government, the guardian, it was qualified by the phrase where the parents are not alive. In 2002 order, that phrase where the parents are not alive is absent. That means the guardian, the word guardian under the 2002 government order is applicable even when parents are alive. If guardian has to be construed as a guardian even when the parents are alive, my responsible submission is, it is only the husband that can be the guardian in respect of a marriage. Of course, it could be even in respect of a married man, wife can be the guardian. In a number of cases, maintenance is done by a guardian, wife is employed and husband is unemployed, other like that. And my personal experience, I can tell, for about 3 months I was unemployed. My wife was my guardian. Before I left the bank and enrolled as an advocate, there was some time gap. During that period, naturally, my wife was in employment, therefore she has to be treated as guardian. That is, therefore, the word guardian will have to be interpreted, which has not been at all considered by the division bench of the High Court when it rendered the judgment. Then, my lords, in the general recruitment rules, maximum age limit for OBC candidate is 40 years. Plus, age relaxation is also available. Suppose I am applying for a job in Government of Karnataka and I am employed while applying in some other undertaking or autonomous body under the control of the state of Karnataka. I am entitled for age relaxation under Rule 6 of subject maximum of 5 years to the extent of service I have rendered in that organization. That means effectively, it can go up to 45 years. Therefore, while interpreting the word guardian and interpreting the provision for exclusion from creamy layer, it has to be interpreted in a manner that reservation given to the backward class women is real and not imagined. 45 years is the maximum age limit. And I don't think in our society, even in the present state, where generally it is said the age of marriage is enhanced over a period of time. But I don't think that it has gone beyond 35 years. If this interpretation of including only the parents is taken into consideration, insofar as OBC women are concerned, what would happen? They would be stating the income of their parents when they are not the members of that family. And they would be not, they would not be the husband's income, which is the relevant income, which is a part of the family, that would stand up. Of course, the argument of the other side would be, what family is not mentioned in the government order. But all these government orders will have to be interpreted in the context of and in the light of Indira Sawhney's death. Creamy layer as a concept, though it has been there in our state right from the year 1977 or 1978, it has been there. Income limit. The exclusion by way of holders of office, then the comprehensive creamy layer was for part of judiciary. It was a direction was issued to exclude the creamy layer person for the first time in Indira Sawhney, and it was pursuant to the judgment of the Supreme Court in Indira Sawhney. A fresh exercise was undertaken by way of reference to the backward class commission. The question of defining the creamy layer and 30th March 2002 order was issued. And 30th March 2002 government order is itself at variance with the backward class commission. They say at one place that backward class commission recommendation is accepted. But final order is contrary to the recommendation itself. This also will have to be borne in mind while interpreting the government order dated 30th March 2000. This would be my broad submission. With that, let me now take my words to the pleadings. We might also take the application.
those several notifications were issued. I can point out as one notification in respect of each education district was issued. And all of them are dated 21st of March 2022. And all of them are identical, except where stated the number of vacancies under each subject and each medium. Page 21, annexed A1 is the advertisement.
Yes.
ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ, that is how they refer to recruitment notification. ವಿಷಯ 2021-22ನೇ ಸಾಲಿನಲ್ಲಿ ಪದವೀಧರ ಪ್ರಾಥಮಿಕ ಶಿಕ್ಷಕ 6ರಿಂದ 8ನೇ ತರಗತಿಗಳಿಗೆ ಗ್ರಾಜುಯೇಟ್ ಪ್ರೈಮರಿ ಟೀಚರ್ ಫಾರ್ ಕ್ಲಾಸ್ 68 ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ನೇರ ನೇಮಕಾತಿಯಿಂದ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಯ ಮೂಲಕ ಭರ್ತಿ ಮಾಡುವ ಬಗ್ಗೆ. ಕಾಂಪಿಟೇಟಿವ್ ಎಕ್ಸಾಮಿನೇಷನ್, though they say it is district wide, it was a common examination held on common date for the entire state. Only thing is, merit lists were drawn up for each of the districts separately because the applications were called on district level. No, in this application, in this recruitment notification, the Malad would kindly turn to page 27. Item number 11 there. ಹುದ್ದೆಗಳ ಮೀಸಲಾತಿ. ಹುದ್ದೆಗಳ ಮೀಸಲಾತಿಯು ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸರ್ವಿಸಸ್ ಜನರಲ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ 1977 ನಿಯಮ 9ರ ಪ್ರಮಾಣಾನುಸಾರ ಮತ್ತು ಕಾಲಕಾಲಕ್ಕೆ ಹೊರಡಿಸಲಾಗುವ ಕಾನೂನುಗಳು, ನಿಯಮಗಳು ಹಾಗೂ ಕೆಳಕಂಡ ಜಾರಿಯಲ್ಲಿರುವ ಸರ್ಕಾರದ ಆದೇಶಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಇರುತ್ತದೆ. ಫಸ್ಟ್ ರೆಫರೆನ್ಸ್ ಇಸ್ ಜನರಲ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್. ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ವರ್ಗ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗೆ ವ್ಯಕ್ತಿಗಳಿಗೆ ಪ್ರಸ್ತುತ ಜಾರಿಯಲ್ಲಿರುವ ಮೀಸಲಾತಿ ನಿಯಮಗಳು. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಮೀಸಲಾತಿ ಸೌಲಭ್ಯ ಪಡೆಯಲು ಅಭ್ಯರ್ಥಿಗಳು ಸಲ್ಲಿಸಬೇಕಾದ ಪ್ರಮಾಣ ಪತ್ರಗಳು. ಐಟಮ್ 3 there. ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಪ್ರವರ್ಗ 2A, 2B, 3A ಮತ್ತು 3B ಈ ವರ್ಗಕ್ಕೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗಳು ನಮೂನೆ F, ಫಾರ್ಮ್ F, ನಿಯಮ 3A(2)(3) ಸರ್ಕಾರದ ಆದೇಶದ ಸಂಖ್ಯೆ ದಿನಾಂಕ 8/2/2000. That's what I was submitting at the threshold. It is not a government order. It is an order by which, or it is a notification by which reservation rules of 1992 are amended. 1992 rules itself is made under section 13 of the Reservation Act, which I would respectfully submit is legislative character. Because section 13 requires any rule made under the Act 1990 to be laid before the legislature, and legislature is also given a power to modify. Laying involves 2 types of procedures. One is simply laying. Legislature has nothing to do. Only thing is ಮಂಡಿಸಲಾಗಿದೆ ಅಂತ ಸ್ಪೀಕರ್ ಹೇಳಿದ್ರೆ ಆಗೋಯ್ತು. The alternatively, there may be another procedure where it should be laid. This section also would stipulate how long it should be laid. And it further states that the rule will be effective only to the extent if it is modified. Only modified rule will be effective. Modification can be done with the legislature. There are two alternative laying procedures. Now my lords may kindly take section 30. Here, lords, before I go take my lords to section 30, I'd like to point out one thing. It is in response to this notification, every one of the applicants and every one of the respondents submitted their application. No protest, no challenge to the recruitment notification, even as on today. Now, let's kindly take section 13 of the Reservation Act 1990.
That is, the Karnataka scheduled caste, scheduled tribes and other backward classes, reservation of appointments, etc. Act 1990. This act came into force Section 1 now is subsection 2. Yes. It shall come into force on such date as the state government may by notification appoint. Then what state government appointed 1/6/1992 as the date of the comes into effect. The notification date is 15/6/1905. Then what section 30. Before that, no? Section 4, capital A. Issue of caste certificate and informal caste certificate. Any candidate or his parent or guardian belonging to the scheduled caste or scheduled tribe may, in order to claim benefit of reservation, either for appointment or for any service or post or for admission, may make an application to any prescribed form. Subsection 2 is pertaining to OBC. Any candidate or his parent or guardian belonging to other backward classes may, in order to claim benefit of reservation under section 4, either for appointment to any service or post or for admission to a course of study in a university or an education institution, may make an application to the Tahsildar in such form and in such manner as may be prescribed for issue of income and capital. The Tahsildar may, on the receipt of such an application under subsection 1 or 2, and after holding such inquiry as he deems fit, and satisfying himself regarding the genuineness of the claim made by the applicant, pass an order issuing a cash birth certificate, or as the case may be, an income tax. Can you mark this model? The application has to be made by the candidate or his parent or his guardian. And the word guardian itself is not defined in the act. Therefore, we have to go by common sense meaning of the word guardian. Then now, can we take section 30? So then now, your 4 capital C is also important. 4 capital C. verification of caste certificate and income and caste certificate. The state government shall constitute one or more verification committees for each district, consisting of such person or persons as may be prescribed for verification of caste certificate and income and caste certificate issued under section 4A or section 4B. Then notice what is the to be done. Then can we come to the section 6D. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Thereafter, the standing committee and all that. Section 13 is the empowering rule to make the empowering provision to make the rule. The state government may make rules for carrying out the purposes of this act. Until such rules are made under subsection 1, any executive order made by the state government relating to such reservation shall be deemed to be rules made under this act. Only until the rules are made. Yes. Every rule made under this act shall be laid as soon as may be after it is made before each house of the state legislature, while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions, and before expiry of the session in which it is so late, or the session immediately following your successive sessions aforesaid, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form, or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule. It has to be late, and only if legislature does not think it necessary to make any amendment or modification, it becomes absolute. Therefore, the rule made under this act is not a subordinate legislation. Once it is laid before the assembly, the legislature, and it does not modify or annul it, it becomes a rule made as if by the legislature itself. It stands on a higher pedestal than any executive order of the government. This is what my submission is this. 2000 rule is made under section 30. 2000 rule stipulates how the application has to be made, how the certificate has to be issued, and it also stipulates the form in which application has to be made and form in which the certificate has to be issued. It is not a format prescribed by some executive order to say that format is subordinate to the rule. Such an argument can come because form cannot control the rule. If form and act both have the same parentage, which in this case is the legislature, then it is as if made in the act itself. There is a world of difference between the two phrases, made by the act or made under the act. It is made by the act itself, is made of. Now kindly see 2000, what is the amendment in the rules? The rules are of 1992 vintage. The next page is this Karnataka scheduled caste, scheduled tribes and other backward classes, reservation of appointment rules 1992. These rules at the preamble itself, it notices 1992 rules. GSR 14. In exercise of powers conferred by subsection 1 of section 13 of the Karnataka Scheduled Caste Scheduled Tribes etc. Act 1990, Government of Karnataka hereby makes the following. Now, my lords, the 2000 amendment rules, which is referred in the recruitment notification as government order dated 8/2/2000, is annexure A2 at page 48 of the application. ಕರ್ನಾಟಕ ಅನುಸೂಚಿತ ಜಾತಿಗಳು, ಅನುಸೂಚಿತ ಬುಡಕಟ್ಟುಗಳು ಮತ್ತು ಇತರ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ನೇಮಕಾತಿ ಮುಂತಾದವುಗಳ ಮೀಸಲಾತಿ ಅಧಿನಿಯಮ 1990 13ನೇ ಪ್ರಕರಣದ ಮೂಲಕ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರವು ಕರ್ನಾಟಕ ಅನುಸೂಚಿತ ಜಾತಿಗಳು, ಅನುಸೂಚಿತ ಬುಡಕಟ್ಟುಗಳು ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ನೇಮಕಾತಿಗಳು ಮುಂತಾದವುಗಳ ಮೀಸಲಾತಿ ನಿಯಮಗಳು 1992 ಮತ್ತಷ್ಟು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಈ ಮುಂದಿನ ವಿಷಯಗಳನ್ನು ರಚಿಸಿದೆ. It is framed under Article Section 13 of the Act. Now kindly go to page 49. Rule 3 capital A, which is inserted by this order. It will be there in the book also, but I refer to this document because I want to bring to my kind of know that it is made under section 30. And please, yes. ಜಾತಿ ಪ್ರಮಾಣ 3A, ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಗೂ ಆದಾಯ ಮತ್ತು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರಗಳ ನೀಡಿಕೆ. 4A ಪ್ರಕರಣದ ಅಡಿಯಲ್ಲಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಮತ್ತು ಆದಾಯ ಮತ್ತು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರಗಳಿಗಾಗಿನ ಪ್ರತಿಯೊಂದು ಅರ್ಜಿಯು ಕ್ಲೇಮಿನ ಸಮರ್ಥನೆಗಾಗಿ ಅಂತ ದಸ್ತಾವೇಜುಗಳು ಮತ್ತು ಅವಶ್ಯಕವಾದ ಇತರ ವಿಷಯಗಳೊಡನೆ ಸೂಕ್ತವಾಗಬಹುದಾದಂತೆ A, B ಮತ್ತು C ಅಥವಾ C ನಮೂನೆಗಳಲ್ಲಿ ಇರತಕ್ಕದ್ದು. 2. ಅರ್ಜಿಯನ್ನು ಸ್ವೀಕರಿಸಿದ ನಂತರ ತಹಸೀಲ್ದಾರ್ ಅರ್ಜಿದಾರನಿಗೋಸ್ಕರ ಮಾಹಿತಿಯನ್ನು, ದಸ್ತಾವೇಜುಗಳನ್ನು ಮತ್ತು ಅಂತ ಅವಶ್ಯಕವಾದ ಇತರ ವಿಷಯಗಳನ್ನು ಪರಿಶೀಲಿಸತಕ್ಕದ್ದು ಮತ್ತು ಅಂತ ಪರಿಶೀಲನೆಯಿಂದ ಅರ್ಜಿದಾರನು ಒದಗಿಸಿರುವ ಮಾಹಿತಿ, ದಸ್ತಾವೇಜುಗಳು ಮತ್ತು ಸಾಕ್ಷ್ಯಗಳು ಸರಿಯಾಗಿವೆ ಎಂಬ ಮನವರಿಕೆಯಾದ ನಂತರ ಆತನ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಮತ್ತು ಆದಾಯ ಮತ್ತು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸೂಕ್ತವಾಗಬಹುದಾದಂತೆ D, E ಅಥವಾ F ನಮೂನೆಗಳಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕದಿಂದ 2 ತಿಂಗಳ ಒಳಗಾಗಿ ನೀಡಬಹುದು. Applications are to be made in forms A, B or C as the case may be. Certificate is to be issued in form D, E or F as the case may be. Now can we see the Rule 14 at page 56. Rule 15. Rule 15. ನಮೂನೆ A, B, C, D, E ಮತ್ತು F ಗಳ ಸೇರ್ಪಡೆ. This is also included in the rule itself. It cannot be treated as an annexure to the rule. Yes. ನಮೂನೆ A, B, C, D, E ಮತ್ತು F ಗಳ ಸೇರ್ಪಡೆ. ಸದರಿ ನಿಯಮಗಳ ನಮೂನೆ 1ರ ಮೊದಲು ಈ ಮುಂದಿನ ನಮೂನೆಗಳನ್ನು ಸೇರಿಸತಕ್ಕದ್ದು. Now can you see ನಮೂನೆ 3 C. There is another rule that is Rule 7, that is inserted at page 53.
Yes.
Page 53.
Yes.
ಏಳನೇ ನಿಯಮದ ಪ್ರತಿಯೋಜನೆ ಪ್ರತಿಯೊಂದು ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ದಟ್ ಇಸ್ 53ನೇ ಪೇಜ್.
Yes.
They see what are the things to be verified and then sub-rule 3 there. ಅಂತ ವಿಚಾರಣೆ ತರುವೆ ಅರ್ಜಿದಾರನ ಕ್ಲೇಮ್ ನಿಜವೆಂದು ಸಮಿತಿಗೆ ಕಂಡು ಬಂದರೆ ಅದು ಕೋರಲಾಗಿದ್ದ ಪ್ರಮಾಣ ಪತ್ರವು 1 year ನಮೂನೆಯನ್ನು ನೀಡಬಹುದು. Every form is now made part of the rule itself.
Yes.
Then can we see namune C? That is at page 60. Candidate has to make an application to the Tahsildar in this form.
Yes.
That form reads Srimati, Sri or Srimati, your maga, magalu, patni, athava pati. Spouse is included.
Yes.
ಎಂಬ ನಾವು ಮೀಸಲಾತಿಯ ಕ್ಲೈಮ್ ಮಾಡಲು ಆದಾಯ ಮತ್ತು ಜಾತಿ ಪ್ರಮಾಣದ ಪತ್ರ ನೀಡಿಕೆಗಾಗಿ ಈ ಮುಂದಿನ ಮಾಹಿತಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತಿದ್ದೇನೆ. Then column 4 there. ತಂದೆ ತಾಯಿ ಪೋಷಕ ಪತಿಯ ಹೆಸರು ಮತ್ತು ಉದ್ಯೋಗವು ಸರ್ಕಾರಿ ಅರೆ ಸರ್ಕಾರಿ ಸಾರ್ವಜನಿಕ ಉದ್ಯೋಗ ಎಕ್ಸೆಟ್ರಾ. ಅಭ್ಯರ್ಥಿಯ ಈಗಿನ ವಿಳಾಸ ಪ್ರೆಸೆಂಟ್ ಅಡ್ರೆಸ್ ನಾಟ್ ಪಾಸ್ಟ್ ಅಡ್ರೆಸ್. Then ಜಾತಿ 7. Thereafter 9. ಅಭ್ಯರ್ಥಿ ತಂದೆ ತಾಯಿ ಪೋಷಕರ ತಂದೆ ತಾಯಿ ಜೀವಂತವಿಲ್ಲದಿದ್ದರೆ ಪೋಷಕ ಬರೋದಿಲ್ಲ. Because husband and wife separately they have added. ವಾರ್ಷಿಕ ಆದಾಯ ಸರ್ಕಾರಿ ಅರೆ ಸರ್ಕಾರಿ ಸಾರ್ವಜನಿಕ ಉದ್ಯಮ ಖಾಸಗಿ ಸೇವೆಯಲ್ಲಿದ್ದರೆ ವೇತನ ಶ್ರೇಣಿ ಜಮೀನಿನ ವಿವರ ಇತರ ಮೂಲಗಳು. 10 ಮೇಲಸ್ತರದ ಸೂತ್ರಗಳನ್ನು ಅನ್ವಯಿಸಿದ ನಂತರ ಅಭ್ಯರ್ಥಿ ತಂದೆ ತಾಯಿ ಪತಿಯ ಇದಕ್ಕೆ ಅರ್ಹನಾಗಿದ್ದಾನೆ. ಎಲಿಜಿಬಿಲಿಟಿ ಆಫ್ ದಿ ಹಸ್ಬೆಂಡ್ ಆರ್ ವೈಫ್. Therefore, this application envisages 3 situations. In respect of an unmarried person, poshaka. In respect of an unmarried person whose parents are dead, guardian. In respect of a married person, spouse. 3 categories are categorically made in this. Then kindly go to Namune F, in which the certificate that is at page 64. ನಿಯಮ 3A(2)(3) ನೋಡಿ. ಪ್ರವರ್ಗ 1 ಹೊರತಾಗಿ ಹಿಂದುಳಿದ ವರ್ಗ ಇತಿಹಾಸದಲ್ಲಿ ನೀಡುವ ಆದಾಯ ಮತ್ತು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಡ್ಯಾಶ್ ಅಲ್ಲಿ ವಾಸವಾಗಿರುವ, that is residence. Residence of the married women cannot be her parents' house. It will have to be necessarily ಎಲ್ಲ ಅಂದ್ರೆ ಡೆಸರ್ಷನ್, ಡೈವರ್ಸ್ ಎಲ್ಲ ಬಂದ್ಬಿಡುತ್ತೆ. ಶ್ರೀ ಮತ್ತು ಶ್ರೀಮತಿ ಇವರ ಮಗ ಮಗಳು ಪತ್ನಿಯಾದ ಶ್ರೀಮತಿ ಕುಮಾರಿ ಇವರ ಆತನ ತಂದೆ ತಾಯಿ ಪೋಷಕರು ಪತಿಯು ಸರ್ಕಾರಿ ಆದೇಶಗಳ 17/9/94 31/1 ನಿರ್ಧರಿಸಿರುವ ಮೇಲ್ಸ್ಥಿತ ಕ್ರಿಮಿನಲ್ ಲೇಯರ್ಗೆ ವಾಪಸ್ ಬರುವುದಿಲ್ಲ. All these people have submitted application certificate in form F stating parents in. Then, my lords, kindly take connection A3, which is the government order dated 11th April 2002. This is not issued under any provision of the Act. What it reads is subject. Reservation for administration as per Article 15.4 and employment as per 16.4 and new creamy layer policy orders regarding. The order commences at page 67. Clause 1 of this order, the quantum of reservation specified in government order dated so and so is continued for admission to education institutions and employment. Quantum of there is no change. Revised list of backward classes central to this order is a connection equal to the criminal is brought into force with immediate effect. That is, clause 2 deals with revised list of backward castes. 3. A new comprehensive creamy layer policy as detailed in Annexure 2 to this government order is brought into force with immediate effect. Creamy layer policy does not apply to SC, STs and category 1 of the backward classes. Now, by virtue of the latest judgment, even that there is a direction of the state governments to the union government to formulate creamy layer policy for SC, ST also. This is the latest figure, but you know, we are dealing with a fast case, therefore, we are not able. Candidates belonging to category 2A, 2B, 3A, 3B shall be entitled to reservation in the manner specified in the new comprehensive creamy layer policy. Now, can we turn to page 81. This is the new creamy layer policy. Under Article 15.4 and 16.4 of the Constitution of India, the following persons shall not be eligible for reservation of seats, or posts categorized under 2A, 2B, 3B, and 3A, 3B. That word off it appears. Or reservation of seats or posts. Last page 81. In the second line, seats are posts. Note 1. This rule will not apply to the requirements to posts which insist on period prescribed of service in a lower post or experience in a post or profession or occupation or a qualification or eligibility. That is in-service candidate. And this issue is decided in by the Supreme Court already in case Sharda. That is the point. By the High Court in case Sharda's case. The prevalence order was affirmed. Then the rule. This rule applies to sons or daughters of the person specified below. This sons or daughters applies only to item 1 is the table below, not to 2, 3, and 4. I will read the 2, 3, and 4. I will make good my submission by reading the entries.
That is true. That we observed yesterday also. Call that the tabling is erroneous.
Tabling is what happens is government will always be late in implementing the decisions. Perhaps next day there must have been some contempt proceedings coming up from the Supreme Court. They have calculated 5 ಗಂಟೆಗೆ ನಾನು ಕಂಟೆಂಪ್ಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಆಫೀಸ್ ಫೋನ್ ಮಾಡಿದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್. They have all the time in the world, but they have this characteristic of an advocate. Advocate ಫೈಲ್ ಟೇಬಲ್ ಮೇಲೆ ಬಿದ್ಕೊಂಡಿರುತ್ತೆ. ಕಾಸ್ಟ್ ಇಷ್ಟು ಬರೋವರೆಗೂ ಓದೋದಿಲ್ಲ. Even when colleague comes and reminds, sir, ಅದು ಹಾಗೆ ಹೋಗ್ಕೊಂಡಿದೆ ಏನ ಬರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ನಾಡಿದ್ದೆ ನಾನು ಬರೋದು ನೋಡೋಣ ನೆಕ್ಸ್ಟ್ ಡೇ ನಾಳೆ ಲಿಸ್ಟ್ ಬಂದು ಅದು ಐಟಮ್ ನಂಬರ್ 1 ಇದ್ರೆ ಆಗ್ಬೋದು ಅಂತ ಹೇಳುವ ಇಲ್ಲದೆ ಆದ್ರೆ ಪಾಸ್ ಓವರ್ ಕೇಳೋದು ಮಧ್ಯಾಹ್ನ ಓದ್ಕೊಂಡು ರೆಡಿ ಆಗ್ತೀನಿ ಬಟ್ ಗವರ್ಮೆಂಟ್ ಕೆನಾಟ್ ಅಫೋರ್ಡ್ ಟು ಸೀಕ್ ಪಾಸ್ ಓವರ್ ಇನ್ ಕಂಟೆಂಪ್ಟ್ ಮ್ಯಾಟರ್ ಬಟ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ಇನ್ ದಿ ಕೇಸ್ ಆಫ್ ಪಾಸ್ ಓವರ್ Item 1, sons or daughters of the following person. Item 2, the candidates of and either of whose parents were guardian. The guardian in case of parents are not alive, a guardian, even when parents are alive. Our guardian is a Group A or Group B officer in the service of the government or holds an equivalent post in public sector undertakings or an employee of a private industry, institution and draws a salary of which is not less than that of a Group B officer. 3. Candidate and his or her father, mother's guardian gross income exceeds rupees 2 lakhs. The candidate and his or her father, mother holding 10 units of agricultural land and such of those holding more than 20 acres of plantation. So this applies to guardian even when parents are alive. Now the question would be, who is the guardian when parents are alive? I don't want to make any waste the time of the court to say who will be the guardian before marriage, because that is not the issue that is here. Here the issue is who would be the guardian after marriage. My respectful submission would be, it is the spouse alone who can be guardian, whether male or female. Who could be the guardian? This can be tested very easily. Now, the word family is not used here. But normally, whom does the family consist of? Or what are the tests to say whether it is a family? Living together is one of the. And there are definitions in service rules. Let us take any rule that is applicable to the servants of the state of Kerala. Medical attendance rules or LTC rules. Whatever we take, family is defined as including the husband and not the parents after that. Parents also can be included, provided they are residing with you and they are wholly dependent on you. If they are wholly dependent on me, taking their income into account will not arise. Qualification. It is the husband who constitutes Rule 8, Sub-Rule 16. Sub-Rule 16. Family means the wife or husband the moment a person is wife or husband, automatically included. and legitimate children including such children of the government servant, residing with and wholly depend on the government servant, and for the purposes of traveling allowance for journeys and transfer, also includes the parents residing with and wholly dependent on the government servant. Test of dependency is prescribed only in respect to the parent. Otherwise, wife or husband is automatically included. This definition, Mano, it takes into account realities of life. What is a family? ಅದು ಬಹುತೇಕ ಸಂಸಾರ ಕುಟುಂಬಗಳಲ್ಲಿ ಅದು ಆಗ್ತದೆ. ಮದುವೆ ಆದ ತಕ್ಷಣ ಸಪರೇಟ್ ಮನೆ ಮಾಡ್ತಾನೆ. ಇದೆಲ್ಲ therefore societal realities of life have been taken into account when making these definitions. Then subsequent, therefore my response submission. When this 30th March 2002 government order is only an executive order, it cannot have any effect to the extent it is contrary to statutory rules made under the act. Made by the act. Then this government order itself has to be read in consonance with those rules. It uses guardian if parents are not alive. This uses the guardian independently, but excludes husband or wife. Therefore, the word guardian used in this government order will have to include husband and wife. Husband or wife as the case may be. After all, while interpreting any statute, text should be taken into consideration, but context also should be taken into consideration. Now suppose the word guardian is omitted. What happens? Take the case of, now the age applicable is 45 years. If 45 years is the age, and if a male candidate is a widow by death, parents' income will be an artificial income to be taken because he is not living. Husband's income, husband is not alive. Then it becomes the husband is not included here. She will have no guardian also. And for a woman, say at the age of 40 or 42 or 44, parents may not be alive. If parents are not alive, if this government order textually has to be applied, ignoring the word guardian, parents are not there, therefore there is no income. That can be the criteria to be followed. It has to be interpreted in the context in which the words are there. And having regard to the evolution, what is the evolution? From 1983 onwards, the orders have been placed on record. I can say the incompetence even earlier. ಪೋಷಕರು ತಂದೆ ತಾಯಿ ಇಲ್ಲದಿದ್ದಲ್ಲಿ, that word has been removed. Therefore, all these will have to be comprehensively read. And my respect to submission. that the guardians, the word guardian used there, will include spouse or can mean only the spouse. Can mean only the spouse in case of a married man or married. That is why submission on this government order. There is another aspect of the matter, that is, Indira Swami approved the Mandal norms, Mandal Commission norms for identification of backward class. I'll take my notes to the. There it extracts the norms evolved by Mandal Commission, which says family, and it also says habitat. It also says household. I just take my notes to the. I have got the copy. Huh? Only that one, the Mandal Commission. It is reported in 1992 supplement 3 FCC page number 8. Page number 1. The cycle. Page 250. I have to definitely I am obliged to furnish unreported, not the reported books. It is somewhat the optics. Entitled to a copy of that. I am entitled to a copy of cover education addressed to the. All right, then we have to spend another 100 rupees for Zara.
1 minute, 1 minute. You are not the points to educate it, but the thing is clear. It has quite often, these controversies came up before me also in that red building. Probably the point is clear, made clear by not only by our High Court, even if I remember correctly, by the Appeals Court also. In so far as the reported judgments are concerned, if the counsel referring same to cites the reference, the citation, that is sufficient, he need not have to furnish a copy. Unreported judgment, he is required to furnish a
I
copy.
have to furnish because it is not accessible. Now even that is doubtful because expedition number website that you can see.
Even strictly speaking, ಕೋರ್ಟ್ಗೂ ಕೂಡ ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್ ನ ನೀವು ಕಾಪಿ ಕೊಡಬೇಕಂತ ಇಲ್ಲ.
But
ನಮ್ಮಲ್ಲಿ ಲೈಬ್ರರಿ ಇದ್ರೆ we have to secure it, but the obligation and the duty of the learned counsel is that morning itself, before the commitment of the court, they have to hand over the citation to the court officer so that he can secure those journals. ಅಂತ ಇದೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಜರ್ನಲ್ಸ್ ಗಳೆಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಇರಲ್ಲ, ಕೊಡ್ತೀರಿ ನೀವು. ಸೊ ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಸೈಟೇಷನ್ ಇಸ್ ಸಫಿಶಿಯಂಟ್ ಅಂತಿದೆ. ಕೊಡೋದು ಬಿಡೋದು ವಕೀಲರು ಇಷ್ಟ.
Why I am giving it while making the judgment of the all the judgments of the books of the it becomes cumbersome. Our job ends once the moment we conclude.
Yes.
More for the convenience of the court.
Yes.
In this judgment, my lords, the my lords would kindly take paragraph 124.
Yes.
That is at page
395.
395.
Yes.
In chapter 11 of the report, volume 1, part 1, under the caption Socio-Economic Field Survey and Criteria of Backwardness, it is categorically stated that after most comprehensive inquiries and survey in the socio-economic field, with the association and help of top social scientists and specialists in the country, as well as experts from a number of disciplines, the Commission has prepared the indicators, criteria for social and educational backwardness on the analysis of the data submitted in the report. The relevant paragraph 11.23, 11.24, and 11.25 showing the criteria for identification of backwardness are as follows. Indicator class A and B, my lords, may skip. Class C, economic. Cash bar classes where the average value of family assets is at least 25% below the state average. Can you mark the word family? Next clause, what's the next indicator? That is at page 396. Cash classes where the number of families living in kacha houses is at least 25%. Living becomes relevant. Next is cash classes where the source of drinking water is beyond half a kilometer for more than 50% of the households. Household, which again takes into consideration the residents. 11. Cash where the number of households having taken consumption from loan is at least 25% above the state. The emphasis is on family and where the candidate stays. And this is approved by the Supreme Court at paragraph 795. At page 726. Para 785, they go on talking about what could be the appraisal notions and all that. At classical H method, that is last two lines from the bottom. We may add that relevancy of the criteria evolved by the Mandal Commission has not been questioned by any of the councils before that. Actual identification is a different matter, which we shall deal with elsewhere. That is relevancy of the criteria adopted by the Mandal Commission was accepted by everybody, including the state of Karnataka, which was also heard in the matter, and Karnataka references are also there in the. Therefore, the government order 30th March 2002 has to be interpreted on the angle of Mandal norms, which define family as a unit. Even applying the Mandal norm enunciated at para 124 and approved at para 795, the word guardian in that government order will have to take into account family as a unit and family in respect of a married person, whether male or female.
It will be the family of the spouse and not family of the parent. Therefore, the guardian will have to be interpreted in a pragmatic and common sense manner. ಇವ್ರ ಕುಟುಂಬ ಅಂತ ಹೇಳ್ತಾರೆ, ಯಾರನ್ನ ಪರಿಚಯ ಮಾಡಿಸ್ಬೇಕಾರೆ ಕನ್ನಡದಲ್ಲಿ. ನಾನು ರಾಜಗೋಪಾಲ್, ನನ್ನ ಕುಟುಂಬ ಅಂತ ಹೇಳಿ. ನನ್ನ ಕುಟುಂಬ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಮೈ ಫ್ಯಾಮಿಲಿ, not somebody else's family. I won't say that she is the daughter of so and so. I would say ನನ್ನ ಕುಟುಂಬ. Therefore, family in respect of a married person, irrespective of whether male or female, would be the family of the husband, and so viewed. It is the husband's income that becomes our. Now, my lords, there is a contention that marriage will not change the caste. Right, Honorable? I am not talking of the caste. In fact, under the Modi, under Indira Gandhi norms, first identify the caste belonging to backward class. Suppose I am a Banijiga. I continue to be a Banijiga even after marriage. I would not acquire the caste of the husband. But while applying creamy layer is irrespective of the caste. Creamy layer, it is the income, land holding, family assets. These are the relevant criteria. Unfortunately, the High Court did not notice the word guardian in the government law. It is omission to look at a part of the applicable rule, which renders it, which denudes it of any precedential value. Then notice there are a number of judgments under Guardians and Wards Act. Who will be the guardian? Of course, now that question. This child marriage is prohibited. It may not be very relevant, but even a minor is married, above a particular age, it's a marriage. Marriage will be voidable and not void. For ages, right from Privy Council text, the word guardian, insofar as married women is concerned, has been interpreted by the court, saying that it is the husband alone who is the guardian. And in one judgment it is said, father ceased to be de jure guardian. And it is in fact de facto also. Because factually also she is transplanted from parents' family to parents' abode to husband's abode.
Now that all those concepts are in serious debate and totally contrary view are surfacing, not just surfacing, they are getting recognition in several judicial dictum also, right? You must be having quite good number of women juniors also.
They in relationship.
That is one step ahead. Do not know where to go.
But I think who want to understand those concepts. Even with that concept, they will play. Living partner will be the guardian and not the father.
Till his credit card exhausts or bank balance.
ನಾನು ಮುಂಚೆ ಇದು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ನೋಡೋದ್ ಮುಂಚೆ ಲೈವ್ ಇನ್ ಪ್ರೋಗ್ರಾಮ್ ಅಂತ ಬರ್ತಾ ಇದೆ. ಮಿನಿಸ್ಟರ್ ಕೂತ್ಕೊಂಡು ಟಿವಿ ಇಯರ್ಫೋನ್ ಹಾಕೊಂಡು ನಮ್ ಕ್ವಶನ್ ಆನ್ಸರ್ ಅದೇ ನಮ್ಗೆ ಆಗ್ತಿಲ್ಲ ಬಟ್ ನಾವು my days are numbered and you know I will not I have not undergone it, time is not now at my age, even if I want to live with somebody, nobody will come for living partnership. Therefore, whether we apply common sense, that's it. This is Krishna SP Kulusreshta, who said the issue was very simple. For the post of a lecturer in university, the qualification prescribed was high second class. Allahabad Court interpreted it. It was not correct. The matter went to Supreme Court. Then Krishna, in his usual flourish, he said, there is paralysis of English in Allahabad University. One statement he makes. Another statement he makes it. If 50% is second class and 60% is first class, common sense tells us that high second class means 55% are above. And most important sentence for us. Common sense is not enemy of good sense. Okay, they have a look at that because JP Kulusreshta 1980, volume 3 SCC 418. Para 13 at page 425. Now we come to close grips with the principal point debated before us. When is that second class high going by mark? For any layman, the meaning is clear. For any purpose-oriented interpretation, the decoding is simple. High is the antithesis of low, and the high second class is therefore a contrast to a low second class. When the range of second class marks is wide, if the candidate who gets that class with marks within the lower half bracket, you cannot say he gets a high second class. If he manages to get 48% marks, he barely gets a second class, not a high second class. And common sense, which is not an enemy of court sense, points clearly to the meaning of high second class as one where the marks fall a little short of first class marks and he narrowly missed first class. In the context of Ordinance 9 and its purpose and the collection of words used in first or high second class, the interpretation will misfire if we disregard the intent and effect of the adjective. Interpretation will misfire high and indifferently read it to mean merely the minimum mark needed to bring the candidates within second class. High is high and the superior second class denotes marks somewhere near the first class. Assuming we relax, dilute and liberalize the rigor clearly imported by the draftsman by using the expression high second class, still it is impermissible to render the word high negatory or make a construction that intensive adjective redundant, nor are the impressed with strange submission that the university has all these years treated a high second class to mean a mere second class, and therefore English has lost its potency in the Allahabad University, not the port. English has lost its potency in Allahabad University, and high includes low. Such pathetic semantics must be respected. This continuing commission of wrong does not right. Three things Lordship Justice Krishna has said in this one paragraph. You cannot rewrite this. Two, you can interpret, but interpretation should be making the rule meaningful. Three, it should be relatable to, it should appeal to the common sense. If I say family income means my parents' income in respect of a married woman, it does not, it is appalling to any common sense. And even textual, when you have removed the phrase where parents are dead, where parents are alive, guardian can be only this spouse. This is the simplest textual, contextual meaning which makes the rule workable, so that people who really deserve reservation are given reservation. Otherwise, what happens? No doubt, as a child studying, a married woman, a female child will be with the parent. That is 22 years. The entire this education is over at 25 years. After you are married and you are transplanted elsewhere, there is neither logic nor any rationale in still taking my parents' income, ignoring the word God. If the word guardian was not there, perhaps not the situation could have been argued to be different. In the presence of the word guardian, it can mean only what.
One small interference, if that were to be the manner of understanding that word, parents, public guardian, then why in forum number F, both the parents, guardian, wife and husband are mentioned.
Forum F earlier to 2000. Forum F was introduced in the year 2000. Forum has not undergone it. Now, subsequently, this executive order has come. There is no challenge to that executive order by the. My effort has been to harmonize the rule, the forum of 2000 and stipulation of 2000. Now, with the 2002, guardian if parents are not alive has become redundant. Guardian has to be read as in a wider perspective as to who can be the guardian than parent are. Because text and context both I have to, and then I have to interpret it in a manner to ensure that objective of the rule is not lost. Objective is to make reservation available to weaker of the weaker sections. Ultimately, all backward caste, if caste is taken, they are backward. Out of them, poorer sections are taken into account by excluding the creamy layer for the purpose of reservation. The poorer sections are to be excluded. You cannot import the past poor, the past poverty to the present. In fact, it's very important interpretation. Principle is stated that is not based on the possibility. In Ramandal Keshav also, what's the state of Gujarat? The constitution is the paragraph, first paragraph of the judgment, penned by Lordship Justice Tinapret. It starts like this. Can a state make a law based on situations that were prevailing 20 years ago? Because what had happened was, some employees of Panchayat had been deprived of their statutory, their offices under the state by saying that they are not government employees. They had worked in the government employees for 20 years. Law was amended. Ramandal Keshav Soni. 1982, 3 SCC, page 33, 83. Just this paragraph 1. It sums up the entire agony of the case. Now, today, when you are providing to a person reservation today, you cannot take into account her past poverty. And please remember this. A reservation certificate, that is income certificate issued in respect of OBC, which is income related also, is valid only for 5 years. Whereas a caste certificate issued for the scheduled caste or scheduled tribe, it is valid till it is cancelled. Therefore, it is the present poverty that has to be taken into consideration and not past poverty or past riches. I may be daughter of a rich landlord. In the same caste, I might have been married to a lesser affluent family. Then my past riches cannot deprive me of reservation in the present. And objective is to, the entire objective of criminal, my Lord Sutta, kindly appreciate this aspect, is to exclude the better off segment in the caste identified to be backward. There is a difference between backward caste and a backward class. A backward caste, if creamy layer is chopped off, it becomes a backward class. And reservation under Article 16(4) is for backward class and not backward caste place. There will be some castes who can be presumed to be backward class. There are only two such categories: scheduled caste, scheduled tribe, and group 1, category 1, where this category 1 and the one, and then one immediately that comes to my mind is that amongst Muslims, one category is included. That is Pinjara is not among the very Darvish. Darvish have ಏನು income. Darvish is then. Darvish is job or his occupation is. He is properly called as a religious mendicant. ಒಂದು ಕಾಲ್ದೀಪದಲ್ಲಿ ಮೇಲೆ ಸಾಂಬ್ರಾಣಿ ಹಾಕೊಂಡು ಹೋಗ್ತಾ ಇರ್ತಾರೆ. ಸಾಂಬ್ರಾಣಿದ ಹೊಗೆ ಬರ್ತಾ ಇರುತ್ತೆ. ಪ್ರತಿ ಮನೆಗೂ ಹೋಗಿ ನವಿಲ್ಗರಿಲಿ ಮಾಡೋದು. He is a religious mendicant. A religious mendicant, you cannot, no income limit is prescribed. In fact, Darvish, I remember a very interesting statement rendered by Lordship Justice Ramadev. He said, Darveshu, suppose a Darveshu, a person belonging to Darveshi caste or community or class, he takes up an employment. His son ceases to be a Darvesh. That came in for a lot of criticism, but that held the field in the state for more than 10 years. Ultimately, that issue came up after this capitation fee and all that. Before a division bench entered the National Justice Mujumdar. State, for state, Mr. S. Vijay Shankar, advocate, D appeared and said, my lord, Sarvesu, he has stopped begging. Then the reply of the bench was very meaningful, said, Mr. Vijay Shankar, forget about begging. With the present fee structure, even you and I will have to beg if we have to send our children to medical course. Luckily, division bench reversed that judgment and affirmation of it came by a civil appeal. Unfortunately, that judgment is not reported anywhere. We want to find that out, it becomes very difficult. Therefore, no, the question is of present power, not the old earlier power. Now, except group 1 and scheduled caste schedule, right? Income is the relevant to it. Once you belong to that caste, nobody has questioned that my clients belong to the caste stated in their certificate or in their application. Their grievance is that I have married, therefore my caste changes. I don't understand. Where is the pleading? Even if I marry into another caste, my caste will not change. Now, a Brahmin girl marrying a scheduled caste boy, she cannot claim reservation applicable to scheduled caste. But there is no law which says a scheduled caste girl marrying into a Brahmin boy ceases to be a scheduled. There is no such rule. My caste remains what it was when I was born. I have no choice. It is determined by birth. But what I am speaking of when it comes to creamy layer is the income rate. The sole question is, under government order dated 30th March 2002, whose income will have to be taken for? In fact, the candidate's income has to be excluded. There is the law of declared in Indra Sami, but that issue is not raised here, therefore that issue becomes lower. The point is only about the property. Then also on the interpretation of statute, since I have taken a lot to illustrate for 2 other judgments I would bring to my lord's kind notice. First is Reserve Bank of India versus Fearless. This is my lord's 1987. 1 SCC 424. Paragraph 33. Page 4. Interpretation must depend on the text and the context.
They are the basis of interpretation. One may well say, if the text is the texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best, which makes the textual interpretation match the contextual. The statute is best interpreted when we know why it was enacted. With this knowledge, the statute must be read first as a whole, and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment, with glasses of the statute maker, provided by such context, its scheme, the section, clauses, phrases, and word may take color and appear different than when the statute is looked at without glasses provided by the context. With these glasses, you must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. No part of a statute and no word of a statute can be construed in isolation. Statutes have to be construed so that every word has a place and everything is in its place. It is by looking at the definition as a whole in the setting of the entire act and reference to what preceded the enactment, the reasons for it. That the court construed the expression placed it in Srinivas and we find no reason to depart. Here the context is not. Earlier this was the phrase was used, which is cut short and this is what is. When the parents are not alive, it's removed. Word guardian is retained. Husband or wife is removed. Which will be contrary to the statutes. That is 2000 amended rules. 2002 amended rules. This executive order will have to be interpreted in consonance with. And of course, from time to time, taking into consideration the inflation, the limits have been enhanced. First it was 2 lakhs, then it is 4.5 lakhs. When 2 lakhs was the limit, the government order indicated husband and wife, their parents are not alive with her. Today, those orders may not be there. It might have been substituted by later on. But substitution of the statutory rule has not taken. Statutory rule has remained what it is. In such an event, only arithmetical correction can be taken into consideration. Again, taking into account the realities as on existing. Then what's another judgment on this interpretation? This is by 3Z, this is Bhavnagar University Varkute, Balitana Sugarni, 2003, 2 SCC 111. Paragraph 23 at page 121. It is a basic principle of construction of statute that the same should be read as a whole, then chapter by chapter section. Before of construction or interpretation of statute is necessary when there is ambiguity obscurity, or inconsistency, they are not otherwise. An effort must be made to give effect to all parts of the statute, and unless absolute necessary, no part thereof shall be rendered profligate or hidden. Therefore, 2000 rule will have to be borne in mind, since it is not repeated. It is not amended. While giving effect to 2002 Act. Otherwise, the word guardian used in the and husband or wife used in the statutory rule will become redundant. That rule has not been. And the exclusion of that phrase where parents are not alive would eminently enable reading the guardian to include husband or wife as stated in the proposal. Then note paragraph 33 in this very judgment. That is about the legal fiction in there. The purpose and object of creating a legal fiction of the statute is well known. When a legal fiction is created, it must be given its full effect. Then paragraph 45. Omitted that they have extracted their legal fiction. Paragraph 5 is 45 fails. In case on statute law, it is the duty of courts of justice to try to get the real intention of the legislature by carefully attending to the whole scope of the statute to be construed. That in each case you must look to the subject matter, consider the importance of the provision, and the relation of that provision to the general object intended to be secured by the Act, and upon a review of the case, in that aspect, decide whether enactment is what is called imperative or only direct. But then, here that question would not come, imperative or direct. But then, to understand it, the whole thing has to be good. In fact, the government order of 30th March 2002 is based on the judgment of the Supreme Court in Mandalpuri. And then it says so in so many aspects, that report itself. But that report also has been based on record in one of the applications. That report is clear, categorically says that it is to give effect to Mandal Commission. Of course, the chairman of that commission has given credit to his own personal view also in that. But ultimately, we are recommending the what is permissible or what is not permissible, and this one only has to come. And while implementing it by the government order added the word guardian. Guardian is not used in the recommendation. Referring to Gujarat versus Samangal case where Arab one maybe. The attitude of the state of Gujarat in these cases has indeed left us puzzled and wondering. On the one hand, there are lakhs of employees working under various panchayat institutions, call them government servants or not, to whom the benefits of the recommendation of the Pay Commission
the Sarela and Desai commissions have been expended. While on the other hand, there is a microscopic number of about 6,000 files of the lowest category, also working under Panchayat institutions, who are denied the benefits of those recommendations on the sole ground of the birthmark, if we may so call it, since they are denied the benefits because before they came to work under the Panchayat institution, they were employed in municipalities, while others were government servants to start with. The unfairness in the industries of the distinction is fatal, whatever legal, whether legal or whatever legal justification we put forward. Surely the state dedicated as it is to socialism, equality and economic justice, and enjoined by the directive principles to secure the right to work, a living wage, equal pay for equal work, and so on, cannot make such distinction. But the distinction has been made. It is sought to be sustained by those making it, and we are constrained to examine whether there is any constitution or the other legal sustenance for the distinction. We did request the Council for the State of Gujarat to communicate with its client to find out if the benefits cannot gracefully be extended to the erstwhile employees of the municipalities presently working under Panchayat institution. We are told that the answer of State of Gujarat is negative. So can they turn the paragraph 53, where they say you cannot make a law based on, that is paragraph 52. It starts at page 61. I would not trouble my lords with readings from the beginning. Fifth line or sixth line at page 62.
Yes.
The law must satisfy the requirements of the Constitution today, taking into account the accrued or acquired rights of the parties today. The law cannot say 20 years ago the parties had no rights. Therefore, the requirements of the Constitution will be satisfied if the law is dated back by 20 years. It is exactly saying this. I am married 10 years ago. Now the government would say, hey, your father was rich. I don't know in these cases whether fathers were really rich or not. But till the requirement notification said you produce the husband certificate, you produce the husband certificate. We are concerned with proceeding with that. We are concerned with today's rights and not yesterday's. Yesterday's rights are today's rights. The legislature cannot legislate today with reference to a situation that obtained 20 years ago and ignore the marks of event and the constitutional rights accrued in the course of the 20 years. There I stop. Therefore, when you decide my right to get reservation, it should be based on my position today, not anterior to 10 years back when I was with my parents. Taking a lift from my house. It is not uncommon these days that a rich father's wife chooses a poor boy. Luckily, in my case, in the same caste they are. Therefore, my lords, proceeding further, after extracting that paragraph from B.S. Yadav, today's equals cannot be made unequal by saying that they were unequal 20 years ago. And we will restore that position by making a law today and making it retrospective. Constitutional rights, constitutional obligations, constitutional consequences cannot be tampered with that way. The law which is made today would be plainly invalid as offending constitutional provisions in the context of the existing situation cannot become valid by being made retrospective. Past virtue, constitutional, cannot be made to wipe out present wife by making retrospective. retrospective law is not made in the instant court. Retrospective situation is sought to be applied by the interpretation put forth by the. Therefore, husband or wife is not wiped out by virtue of the government order dated 30th March 2002. They are still valid. They can be the only statutory consideration to decide my status, whether I belong to creamy layer or not. That's my submission on that issue. Then what?
How long you take with your counsel? How about having it on some other date tomorrow?
Tomorrow I have the full bench sitting.
Monday.
Monday I don't have. Monday 3 o'clock I come. Major point I have covered. Then certain things those you have created at the answer.
Like counsels from both sides in all these matters are present. Heard the argument of learned senior counsel appearing for the learned counsel for the respondents number 12 to 21 in application number 4605 to 4626 of 2023 and respondent number 5 to 7 in application number 4701 to 4704 of 2023 and also for respondent number 12 in application number 4505 to 4713 of 2023 in part. Since tribunal time is over, for his further arguments followed by the reply from the appellant's side, list the matter on 12/1. ಹನ್ನೆರಡು 13 ಬೇರೆ ಸ್ವಲ್ಪ ಮ್ಯಾಟರ್ಗಳಿದೆ. 14 ಹೇಗೆ ಸಂಕ್ರಾಂತಿಯ ಹಿಂದಿನ ದಿವಸ ಆಗ್ಬೋದಲ್ವ? ನೋಡಿ 14 ರಜಾ ಕೊಡ್ಸಿರ್ತಾರೆ ರಾಜಗೋಪಾಲ್ ಅವ್ರು ಹೈಕೋರ್ಟ್ಗೆ. ಕ್ಯಾಲೆಂಡರ್ ಹೈಕೋರ್ಟ್ ಇಂದ ಬಹಳ ಸ್ಪೆಷಲ್ ಮಾಡಿಸಿದ್ರು. 14/1/2026 at 3 PM ಆಗ್ಬೋದಲ್ವೇ?
14/1 BPM.
It's the
Passed over matter.